It looks like we're on.
I'm verifying with Anna for a second.
Great.
So Ms. Kippenbrock has verified that we're on YouTube, as you saw, and she's now posting that link to our website so that the general public has access to it. I think we should. Ms. Kippenbrock has verified that we're on YouTube, as you saw, and she's. Sorry for the feedback there. I still had YouTube open, of course.
Great. No worries. Okay, everybody. Good morning. We are on the record. This time is 9:23 a.m. in Santa Fe, New Mexico. My name is Patrick Schaefer. I'm a hearing examiner for the New Mexico Public Regulation Commission, joined by my co-hearing examiner, Mr. Kevin Getko. We're here for a hearing on the comprehensive stipulation in case number 25-00079 UT. This is in the matter of Southwestern Public Service Company's application for revision of its retail rates under Advice Notice 341 and another associated relief. Notice was given by SPS in this matter as confirmed by the company's notice of filing of affidavits of mailing publication and web publication filed in this docket on February 24th, 2026. We are here today pursuant to the comprehensive stipulation filed in this docket on June 22nd, 2026. I would like to introduce everyone to Mr. Lee, our court reporter. Mr. Lee will also be managing the transcript to this proceeding. So if the parties have any questions regarding that, I would just direct them to Mr. Lee and his team for any answers. I would also just say that Mr. Lee will be swearing all of our witnesses in. So it's important to remember that as we proceed. As I mentioned a few moments ago off the record, we'll be taking breaks around every 75 to 90 minutes, depending on the flow of testimony and cross-examination, for about 10 to 15 minutes, depending on our schedule and how we're proceeding. Now, I would like to have the parties state their appearance for the record, and I will start with SPS.
Good morning, examiners, Commissioner O'Connell, and colleagues. Dana Hardy on behalf of Southwestern Public Service Company, and also appearing with me for SPS are Mr. Patrick Purcell, Mr. William Coe, and Mr. Timothy Rode. And we may also have an appearance from Mr. Patrick Zomer, but he is still waiting on his Pro Hoc Vice paperwork from the state bar. So we will be filing that hopefully as soon as we receive it. Thank you.
Thank you. Thank you, Ms. Hardy. New Mexico Department of Justice is next.
Thank you. Mark Hayden on behalf of the New Mexico Department of Justice, along with Lawrence Marcus, who is also with me today.
Thank you, Mr. Hayden. Good to see you, Mr. Marcus. OPL is next.
Good morning, Your Honor. Michael McMillan for OPL.
Thank you, Mr. McMillan. New Mexico Large Customer Group is next.
Good morning. This is Austin Rushoff on behalf of the New Mexico Large Customer Group. I'm joined by my colleague Rick Arnett.
Thank you, Mr. Rushoff. CCAE follows.
Good morning, Kara Lynch, attorney representing CCAE. I'm also here with Sydney Tejas, who is on the YouTube station.
Thank you, Ms. Lynch. Next, we have FEA and LES.
Matthew Von Drossik with the Air Force Department on behalf of Federal Executive Agencies, or FEA.
And good morning. This is Susan Miller on behalf of Louisiana Energy Services, or LES.
Thank you, Ms. Miller. Next, we have Walmart.
Good morning, Julie Clark on behalf of Walmart.
Thank you, Ms. Clark. Next is Emnerd. Mr. Hall has been excused and will be just participating as an observer. Next, we have Targa Resources.
Good morning, Your Honors. Mark Walker for Targa Resources.
Thank you, Mr. Walker. And finally, we have Public Regulation Commission Utility Division staff.
Good morning, Mr. Hearing Examiners, and this is Judith Amer, and Gideon Elliott will introduce himself.
No need. I'm here.
Thank you, Ms. Amer and Mr. Elliott. Good to have you with us. Okay, so SPS will be the first party in our order of presentation. Why don't we go ahead and stipulate to the testimony and exhibits that SPS filed in this matter and uploaded. Ms. Hardy, would you like to go through your exhibits, and then we can ask the parties if we stipulate, and then we can get that entered into the record.
Sure, I'm happy to do that. It's a bit of a long list, so.
Yes, that's okay. We are
Okay.
patiently moving through all of our procedure. Thank you.
Okay, thank you. The signatories Exhibit 1 is the comprehensive stipulation.
So I'll just say any objection. If there's no objection, I will enter it as admitted. So any objection? It's admitted.
Thank you. Signatories Exhibit 2 is the errata to the comprehensive stipulation.
Any objection? It's admitted.
SPS Exhibit 1 is the direct testimony of Adrian J. Rodriguez, which has been adopted by Zoe E. Lees.
Any objection? It's admitted.
Exhibit number 2 is the direct testimony of Zoe E. Lees.
Any objection? It's admitted.
SPS Exhibit 3 is the supplemental testimony of Zoe E. Lees.
Any objection? It's admitted.
Exhibit SPS 4 is the testimony in support of comprehensive stipulation of Zoe E. Lees.
Any objection? It's admitted.
SPS Exhibit 5 is the direct testimony of Todd A. Wayner.
Any objection? It's admitted.
SPS Exhibit 6 is the supplemental testimony of Todd A. Wayner.
Any objection? It's admitted.
SPS Exhibit 7 is the testimony in support of comprehensive stipulation of Todd A. Wayner.
Any objection? It's admitted.
SPS Exhibit 8 is the direct testimony of Sue Dean Kelly.
Any objection? It's admitted.
SPS Exhibit 9 is the direct testimony of Ann E. Bulkley.
Any objection? It's admitted.
SPS Exhibit 10 is the testimony in support of comprehensive stipulation of Ann E. Bulkley.
Any objection? It's admitted.
SPS Exhibit 11 is the direct testimony of Ross L. Baumgarten.
Any objection? It's admitted.
SPS Exhibit 12 is the direct testimony of Jared J. Cooley.
Any objection? It's admitted.
SPS Exhibit 13 is the direct testimony of Michelle A. Keatsman.
Any objection? It's admitted.
SPS Exhibit 14 is the supplemental testimony of Michelle A. Keatsman.
Any objection? It's admitted.
SPS Exhibit 15 is the testimony in support of comprehensive stipulation of Michelle A. Keatsman.
Any objection? It's admitted.
SPS Exhibit 16 is the direct testimony of Jeffrey T. Kopp.
Any objection? It's admitted.
SPS Exhibit 17 is the direct testimony of Dane Watson.
Any objection? It's admitted.
SPS Exhibit 18 is the direct testimony of Megan N. Scheller.
Any objection? It's admitted.
SPS Exhibit 19 is the direct testimony of Casey S. Meeks.
Any objection? It's admitted.
SPS Exhibit 20 is the direct testimony of Renee Miranda.
Any objection? It's admitted.
SPS Exhibit 21 is the direct testimony of Mark Lytle.
Any objection? It's admitted.
SPS Exhibit 22 is the direct testimony of R. Brent Heffington.
Any objection? It's admitted.
SPS Exhibit 23 is the direct testimony of Matt M. Bulkey.
Any objection? It's admitted.
SPS Exhibit 24 is the direct testimony of Paul J. McGregor.
Any objection? It's admitted.
SPS Exhibit 25 is the direct testimony of Justin L. Gable.
Any objection? It's admitted.
SPS Exhibit 26 is the supplemental testimony of Justin L. Gable.
Any objection? It's admitted.
SPS Exhibit 27 is the direct testimony of Nicole L. Doyle.
Any objection? It's admitted.
SPS Exhibit 28 is the direct testimony of Adam R. Dietenberger.
Any objection? It's admitted.
SPS Exhibit 29 is the direct testimony of H. Craig Romer.
Any objection? It's admitted.
SPS Exhibit 30 is the direct testimony of Richard R. Schruby.
Any objection? It's admitted.
SPS Exhibit 31 is the direct testimony of Tamara Newman, which has been adopted by Yen Lee.
Any objection? It's admitted.
SPS Exhibit 32 is the direct testimony of Laura Brennan, which has been adopted by Naomi Koch.
Any objection? It's admitted.
SPS Exhibit 33 is the direct testimony of Robert L. Miller.
Any objection? It's admitted.
SPS Exhibit 34 is the direct testimony of Allison M. Johnson.
Any objection? It's admitted.
SPS Exhibit 35 is the supplemental testimony of Allison M. Johnson.
Any objection? It's admitted.
SPS Exhibit 36 is the second supplemental testimony of Allison M. Johnson.
Any objection? It's admitted.
SPS Exhibit 37 is the testimony in support of comprehensive stipulation of Allison M. Johnson.
Any objections? It's admitted.
SPS Exhibit 38 is the direct testimony of John M. Goodenough.
Any objection? It's admitted.
SPS Exhibit 39 is the direct testimony of Taylor J. Hurt.
Any objection? It's admitted.
SPS Exhibit 40 is the supplemental testimony of Taylor J. Hurt.
Any objection? It's admitted.
SPS Exhibit 41 is the testimony in support of comprehensive stipulation of Taylor J. Hurt.
Any objection? It's admitted.
SPS Exhibit 42 is the direct testimony of Alexander G. Trowbridge.
Any objection? It's admitted.
SPS Exhibit 43 is the supplemental testimony of Alexander G. Trowbridge, and that is in response to bench request number 1.
Any objection? It's admitted.
SPS Exhibit 44 is a supplemental testimony of Alexander G. Trowbridge in response to bench request number 2.
Any objection? It's admitted.
SPS Exhibit 45 is a supplemental testimony of Alexander G. Trowbridge in response to bench request number 3.
Any objection? It's admitted.
SPS Exhibit 46 is the testimony in support of comprehensive stipulation of Alexander G. Trowbridge.
Any objection? It's admitted.
SPS Exhibit 47 is the rebuttal testimony in support of comprehensive stipulation of Zoe E. Lees.
Any objection? It's admitted.
SPS Exhibit 48 is the rebuttal testimony in support of comprehensive stipulation of Allison M. Johnson.
Any objection? It's admitted.
SPS Exhibit 49 is the rebuttal testimony in support of comprehensive stipulation of Alexander G. Trowbridge.
Any objection? It's admitted.
Thank you. Those are all of SPS's exhibits.
Thank you, Ms. Hardy. I'd just also like to state for the record that SPS application, the hearing examiners take administrative notice of that and enter that into evidence as well. So unless there's any other evidence you would like to offer into evidence, Ms. Hardy, I think we're ready for your first witness.
Thank you. Then SPS calls its first witness, Miss Zoe Lees.
Good morning, Ms. Lees.
Good morning, hearing examiner.
Are you ready to be sworn in by our court reporter?
Yes, sir.
Thank you. Mr. Lee?
Ms. Lees, would you please raise your right hand? You solemnly swear the testimony you're about to give the matter not pending should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, ma'am. Go ahead.
Thank you.
Can you please state your full name for the record?
Zoe E. Lees.
By whom are you employed and in what capacity?
I'm employed by Southwestern Public Service Company as Regional Vice President of Planning and Policy.
And Ms. Lees, you submitted testimony in this case that has been marked as SPS Exhibits 1 through 4, and then also 47. Is that correct?
That's correct.
Okay. And since those have already been admitted into evidence, I don't have further questions for Ms. Lees. She's available for examination.
Thank you, Ms. Hardy. Mr. Elliott or Mr. Amer, which one will be doing cross-exam?
I will, Mr. Hearing Examiner.
Thank you, Mr. Elliott. Now, I understand you requested 55 minutes. Is that correct?
Yes. Yeah.
Okay. Actually, Mr. Elliott, I wonder maybe we can just check in with Chairman O'Connell first to see if he would like to ask questions before we proceed with cross-examination.
Absolutely.
Chairman O'Connell, would you wish to ask questions now or wait until later?
I'm happy to ask my questions now. That might help with whatever list Mr. Elliott has too.
Sure. Please proceed.
Great, thank you. Good morning, Ms. Lees.
Good morning, Chairman.
So just have a few questions and was going to start with the stipulation. So that Exhibit 1.
Yes, sir.
The first question is, page 2, found it again on page 3, statement saying that signatories agree that stipulation is fair, just, and reasonable resolution. I didn't word count. I don't know if that shows up somewhere else in there, but my question is, is fair an important outcome here?
Chairman O'Connell, the commission is charged with evaluating stipulations to ensure that they represent a fair, just, and reasonable resolution to the issues in the case, which is why we stated in the stipulation that the signatories agree that the stipulation does so.
Okay. And then I was trying to get to even a higher level question for myself is, this is a rate case, so we'll be setting rates. My reading of the law is rates have to be fair. Do you agree with, am I reading that right?
Yes, Chairman O'Connell, rates need to be just and reasonable, which indicates that they are also fair.
Okay. And then on a couple of places in the stipulation, like on page 5, down at the bottom of the page, paragraph under the paragraph B says this methodology is specific to this proceeding and is not precedential. Then also find it on page 14 in paragraph C says, except as expressly provided here, stipulation is not binding or precedential in any other proceeding. So
Yes.
should I view those statements as broadly applicable or only in the specific places where it says so?
Chairman O'Connell, I believe that those provisions mean that in our next rate case or any subsequent case, the parties cannot argue that because this was stipulated to, then the commission must make the same decision in an issue similar to the issues resolved in this case by the stipulation.
Yeah, that was my understanding too. I just thought better ask to be sure. Okay, so next question on page 4, paragraph above 1.2. It's a long paragraph. I'm not going to read it. In this testimony provided by staff, the stipulation gets described as a black box settlement. So is this paragraph the one that makes that true, or do you have a different description of how the settlement works in terms of showing how the rates relate to all the cost of service elements?
Chairman O'Connell, I don't agree that this is a black box settlement. The revenue increase identified in the stipulation is a product of the stipulated to provisions in the recitals of the stipulation. SPS responded to a bench request from the hearing examiners after it filed this stipulation, which provided some of the information on how its cost of service would be adjusted, and SPS witness Allison Johnson provides specific detail on how cost of service items will be adjusted due to the provisions of this stipulation, and shows those adjustments in her rebuttal testimony. There is an unspecified $2 million plug in that, but that is a concession that SPS made in order to reach a settlement with the parties, that it would decrease its agreed to revenue increase by $2 million in order to reach a settlement among all the signatories.
I appreciate that. And then following up on that, if you look at page 5, stipulation. Sorry, I'm working on exhibit 1, so if page numbers were off with the errata, but so that 1.3 is a process for accrediting capacity costs with Cunningham. There's a big process described in there. It says methodology is specific to this proceeding and not precedential. So why is it important that that process is in the stipulation at all?
It's important that we define the process for how we are going to direct assign the costs and the benefits of Cunningham battery energy storage, but recognizes that this might become a more complicated issue for SPS given its dual jurisdictional service territory, and provides process after this case in which the signatories, interveners, any interested party can meet and evaluate the treatment of any similarly direct assigned resources to SPS, and workshop how the direct assignment of costs and benefits will work. And it provides that in a future proceeding, the commission is not bound to how the stipulation defines the treatment of the direct assignment of Cunningham BESS in this stipulation.
Okay, so yeah, I'm trying to understand how I ought to weight this thing in the stipulation, and what I heard is it's a back of the envelope and we can throw it away after this case.
I don't agree that it's a back of the envelope. SPS witness Alex Trowbridge can go through the methodology specifically and answer questions on why it's an appropriate way to direct assign both costs and benefits, but also recognizing that this is a stipulated to provision and is non-precedential, that there may be other proceedings in which the commission will be looking at this issue as well.
Yeah, thank you. And I didn't mean to disparage the hard work of anybody that went into all this. I was just thinking in terms of durability that this is not a structure or an institution. It's something in this moment that the company and the signatories thought was needed, and trying to understand if I'm looking at this correctly.
The signatories and the company certainly believe this is needed and that a methodology defined in the stipulation is important so that the company and signatories and interveners know how the costs and benefits are being direct assigned to New Mexico and how that's being done. And the company certainly thinks that this methodology is sound when it comes to direct assignment of costs and benefits of resources in general, but recognizes this is a stipulation and that the commission will likely hear this issue in the future.
And then same question for page 9 with the AED 4CP allocation process.
Yes, sir. And my apologies. Can you repeat the question as it pertains to this?
There's the stipulation seems to rely on allocation of resources, energy, capacity that are at issue in the consideration of this stipulation. So I'm, again, just trying to figure out how durable SPS and the other signatories think these allocation methodologies are, or is it a means to the end of getting this stipulation across the line?
These are certainly negotiated provisions in the settlement that represent a compromise by all parties that were signatories to the stipulation. And as I said before, doesn't have a precedential effect going forward because the commission will likely hear these issues again in future proceedings. And unless we reach a settlement that is approved by the commission in those future proceedings, the commission will be making decisions on these issues in the future.
Thank you. So that was, first question was just these allocation methods. The next was just trying to explore another issue raised by staff that appears to me to be potential asymmetry between how New Mexico sets its rates and how Texas sets its rates. So I've been looking at your Exhibit 47, rebuttal testimony in support of stipulation. There's a big section in that. Let's just say roughly page 46. And I just want to understand better how Texas sets its rates versus New Mexico's future test year law.
Mm-hmm.
So,
Go ahead. Sorry, I was just getting to the page that you directed me to.
okay. My just high level looking at the testimony presented. Texas, you have historic test year, which means it actually has to have happened before it gets put into rates. And then future test year, where you get to project what's going to happen in a future period after the rate request has been filed. So that leads me to believe that, a capital investment can get put into rate base in New Mexico sooner than the allocation to Texas of the same capital investment. So you can have rates in New Mexico going up for same capital investment sooner than you can in Texas. Is that a fair understanding of historic versus future?
So Texas allows utilities to set base rates on a historic basis. So that is correct. Texas also allows utilities to recover infrastructure investment through a variety of rider recovery mechanisms. The generation rider recovery mechanism or generator cost rider recovery mechanism in Texas allows a utility to start recovery of generation infrastructure investment on the date that that infrastructure comes in service, and then is rolled into base rates once the utility files a historic test year case. And there is a true up in that case as well. There's also riders for transmission and distribution as well, investments.
Okay, and does Texas call a battery generation?
No, sir. Texas does not allow for the recovery of battery energy storage in either its GCRR or its transmission rider recovery mechanism, or the TCRF.
Because what I was trying to explore is this mismatch create an incentive for SPS to get 100% cost allocation on batteries to New Mexico?
Sorry, Chairman, can you ask that question one more time? Does the mismatch?
Yeah, what I heard is that you're going to have to use historic test year to put a capital investment like a battery into base rates in Texas, where New Mexico's future test year will allow you to project forward the battery cost and in-service date and put the battery cost in New Mexico rates sooner than in Texas. And in the world where a fast nickel beats a slow dime, does that mean that SPS has an incentive to do things like get 100% cost allocation for batteries like Cunningham to New Mexico?
No, sir, I don't agree with that. SPS plans its generation, including battery energy storage projects on its system on a system-wide basis. The direct assignment of Cunningham BESS is a product of not achieving regulatory approval for that battery in Texas and requesting direct assignment of that project in New Mexico.
Did the Texas decision foreclose future inclusion of Cunningham in Texas rates?
I would need to pull up the final order for that case, Chairman, to double check, but I believe the final order just denied the project to be recovered from Texas ratepayers.
Yeah. So my question is forever or just because my understanding of it, they did not like the competitiveness of the procurement and the inclusion of it late in the planning process. So I'm wondering if when it is used and useful, does it is it still eligible to be in Texas rates?
At this time, it is not. I suppose in the future, if SPS needs to request it be included again, it may, but at this time, we don't have a certificate of convenience and necessity from Texas. In order to do that, we would have to go through that process again. And at this time, the Texas Commission has rejected that application.
Okay. And then in addition to rate base differences between Texas and New Mexico, one of the issues in this case is differences in capacity and energy allocators. Just broadly, if you use the method used in Texas and you use the method that's proposed here and enshrined in the stipulation, do you get the same answer?
I'm sorry, Chairman, I don't understand the question.
You've got two different formulas, right? If you give the formulas the same set of inputs, do these different formulas produce the same answer?
So in Texas, it uses a historic test year. So it's going to be based off of historic allocators and a historic cost of service. That it will be different than using forecasted allocators and a forecasted cost of service, as is allowed under New Mexico law. In Texas, there's more of a regulatory lag on cost recovery because it is a historic test year paradigm. In New Mexico, the state of New Mexico has decided to reduce that lag and to allow for future test year recovery. So it is future costs and future allocators that SPS is allowed under the law to use.
Okay. So SPS serves customers in Roswell. SPS serves customers in Lubbock. Do customers in Roswell want something different from SPS than customers in Lubbock?
So SPS no longer serves customers in Lubbock, but I'll take the same question for
Okay.
Amarillo.
The death of AI.
Yeah,
Sorry.
it's okay. So the question is, do customers in Roswell want the same thing as customers in Amarillo?
Yeah. Yes, thank you.
I think all customers want safe, reliable, resilient electric utility service at just and reasonable rates.
And do you believe SPS provides customers in Amarillo the same thing they provide customers in Roswell?
Sir, I believe that SPS provides all its customers with safe, reliable, resilient electric utility service. Yes.
So if we have two different rate making processes that produce different answers, how do I tell someone in Roswell that it's fair that you're paying more for the exact same thing the folks in Amarillo are receiving?
Well, sir, we're setting rates based on what is allowed and has been found to be fair under New Mexico law. So the New Mexico legislature has found that future test year recovery is allowable and fair, and that a utility can request for recovery based on future allocators and future costs from New Mexico.
Yeah, thank you. I mean, your answer is hitting right exactly where my question is when we're talking about rates have to be fair, whose point of view are we looking at? And what I heard in the answer was it's just the law.
Yes, sir. The legislature has set policy for New Mexico that finds that it is just, reasonable, and fair for utilities to request rates be set pursuant to the future test year.
Well, then how would you answer that question if rates are higher in Roswell than they are in Amarillo? Why that's fair to, say, a family member that lives in each place?
Chairman, I'm going to point out that this is a bit theoretical because I can't tell you right now if that is actually the case, that rates are higher
absolutely.
in Texas
I
than New
accept that.
Mexico.
I know that we've got two different equations, same inputs, different answers, trying to understand. When I get confronted with the question of why that's fair, I'd love to hear what your answer would be.
Yep. the commission is setting rates pursuant to New Mexico law, and that is fair, just, and reasonable. The Texas Commission sets rates in Texas as allowed and pursuant to Texas law, and that is fair and just and reasonable. There are also different mechanisms in Texas that bring in infrastructure investments for recovery outside of historic base rate cases. So that is also needs to be taken into consideration, as Texas has recognized that the historic test year methodologies do create a regulatory lag for utilities, and have sought to mitigate that through rider recovery.
Okay. Thank you. And then in your answers, you talked about how, I think when we were talking about the direct assignment at Cunningham, that there will be a stakeholder process before SPS files the next rate case. I found a few stakeholder processes in the stipulation. Can you give me your list of what SPS has committed to for stakeholder processes?
Yes, sir. And I'm going to scroll through the stipulation as I give you the list to make sure that I don't miss any. Okay.
Great, thank you.
So we have a stakeholder process to evaluate the treatment of directly assigned resources and the jurisdictional allocation of divergent state resource portfolios in future proceedings, stipulated to in this agreement. We agree to a stipulated agreement. Sorry, I'm going through this. On the electric affordability program. We have agreed to convene an electric affordability program, or EAP, Mr. Lee, collaborative working group within 60 days of approval of this stipulation in order to evaluate implementation, data, reporting, eligibility of budget sufficiency, cost recovery, a number of items to be included potentially in our next base rate case. We have agreed to a stakeholder engagement process, again, within 60 days of filing or of getting approval of the stipulation for a public electric vehicle direct current fast charging rate, to discuss that ahead of our next transportation electrification, or TEP, filing. We've agreed to gather intervener input ahead of filing a large load tariff or data center tariff. We call it a large load tariff in the stipulation under 1.20 data centers and large loads. And there was one more.
Yeah, the other one I found was on page 9. It's the...
Yep, behind the meter generation.
Yes.
Yes. I was just reading that and trying to decide if it was stakeholder engagement or study for the purposes of answering your question, but we've agreed, SPS has agreed that it will study the jurisdictional and retail impact of adjusting AED for CP transmission allocators to remove behind the meter generation load in the cost allocation workshops agreed upon in a previous case, which was 25-00085 UT. So those workshops have already been stipulated to.
Okay. And then from your point of view of these 5, which one is the most important?
I think stakeholder engagement on all of these issues is really important. I haven't thought about which one would be the most important because I think all stakeholder engagement is very important, sir.
Which of your children do you love the most?
Yeah, I tell them both are my favorite and not to tell the other one.
Yeah, and then the reason I'm asking that question is when I look at the AED behind the meter process, that looks like a commitment to at least file what the outcome of the discussions is in your next rate filing. I don't see that present in any of the rest of these.
So for the DCRF stakeholder engagement, that provision does require us to file a proposed rate following that engagement.
CCRS, did you say?
DCRF, excuse me, in provision 1.19.
Okay.
Direct current fast charging.
Okay, so two of them, 1.11 and 1.19.
Yes.
I can at least see how I'll get a report when you file your next rate case.
Yep. And then in 1.12, sir, C, any recommendations coming out of the working group, we are required to include that in our next base rate case.
Can you, first of all, I'm a little lost. I don't remember depreciation rates being one of the, so is there actually six?
Nope, I'm in section 1.12, electric affordability.
Oh,
and C.
Okay.
Yep.
Okay. All right.
And it's the last sentence there in C that requires us to include any recommendations from that working group in our next base rate case.
So what do you think include means?
I think we need to at least be reporting on what the recommendations are coming out of that working group at the very minimum.
So the outcome could be we had a working group, we discussed things and we think they're wrong.
Well, if there's no consensus, right, then I think that's something that could affect whether something is a request for approval or not in another case, or whether it's going to be objected to by other parties. But at the very minimum, the commission is going to know what the working group discussed, what recommendations, if any, came out of it, whether those are consented to recommendations or not.
Okay. So then why is there no similar requirement for 1.3?
So under 1.3, SPS is required, shall report on recommendations from stakeholder evaluation in its next base rate case. So we are also similarly required to report on the stakeholder process to evaluate the treatment of directly assigned resources as well. And my assumption is that report is going to come along with a request on direct assignment of those resources. Or if there is no request, it will just report out on what the stakeholder process recommends.
Okay. So you're committing that 1.3, 1.11, 1.12, 1.19, there will at least be a report in the rate case. Then what's the process in 1.2? Or 1.20, sorry, the large load.
Oh, sorry, I scrolled all the way up. Hold on.
Right, yeah, 20, not 2.
So the commitment is that SPS will gather intervener input on the large load tariff before filing it. We are in that process now. Actually, we have met with many of the signatories and interveners on a future large load tariff filing.
Okay. And then I'll just tell you, one of my frustrations with these settlements is stakeholder processes are a frequent feature and they look good when you see the stipulation. When you get to the next rate case, how did they play out is like, well, I had a meeting, they chose to show up, didn't show up, and there we have it. There is no commitment from the company to do anything other than that bare minimum. It's fair because it's legal construct. And then what comes out the back end, it's clear that two people sat in a room and said things, but it's not clear that there was any listening going on. And so I'm trying to understand how much weight I should give these stakeholder commitments when I'm evaluating, especially the contested portion of the stipulation, because as I was reading the testimony, that's the solution to the problem that has been identified is we'll fix it by having stakeholder meetings, and we'll do that before we file our next rate case. Well, there's nothing in here. Help me understand how there's anything in here other than I should expect a different approach than I'm seeing in this rate case.
Well, first of all, as I said before, SPS takes stakeholder engagement very seriously and thinks it's very important. The signatories also think it's very important, which is why those are stipulated provisions in this agreement. The signatories requested that there be stakeholder engagement, and that we hold that on these provisions ahead of the next base rate case. I would like to think that signatories think that stakeholder engagement is important because it has found it valuable in the past. And certainly SPS is willing to provide more detail on the engagement should the commission seek it or want to understand it better. We can do that either in direct cases or in response to bench requests. But if it's more detail that the commission seeks, we can explore different ways of doing that.
Well, can you describe the stakeholder engagement processes that SPS used in advance of this rate case?
Yes, sir. First of all, in general, we are usually meeting with interveners and other stakeholders on many different issues. But we did meet with the parties in this case ahead of filing it to review SPS's request and to answer any questions before filing that the stakeholders may have had.
Yeah, again, was that a hearing session or a listening session when you're answering questions?
So we offer to meet with staff and other parties. We go over kind of what the case is going to be presenting and then ask for feedback and ask if there's any questions that we can answer. Oftentimes we'll offer to have another meeting after that initial meeting if folks have more questions before we file.
Yeah, I mean, the point I'm trying to get at is answering questions is good, meeting with people is good, but do you go into those meetings with an open mind thinking, hey, this will change how I'm going to file this rate case?
You know, I think we do keep an open mind when we're doing pre-filing meetings. Pre-filing meetings, though, Chairman, are not the only type of stakeholder meetings we have. And as the stipulation shows, there are stakeholder engagement that is focused on specific issues ahead of a filing, right? To work out issues before the commission puts, or excuse me, before the company puts together an application. Certainly, there are filings where we meet with folks well ahead of the filing so that we can get early feedback and incorporate that into the filing itself. That is something that we are doing right now with a future large load tariff filing.
Okay, thank you. Then just one smart aleck question.
Okay.
If just and reasonable means fair, how come the law says fair, just, and reasonable?
Sir, because that is what the legislature wrote into the Public Utility Act.
Yeah, there's no possibility that each of those three words stands on their own. A equals B plus C.
I think the commission is charged with evaluating the settlement to ensure that it meets the fair, just, and reasonable requirements in the Public Utility Act. It has to evaluate all three.
Thank you for no help. Okay, so that concludes the questions I came in to ask today, hearing examiners Schaefer and Gecko. I'm not going to be able to be here for this whole hearing, so I'm going to come and go. But I think you get what I'm struggling with, and we've got a lot of customers signed on to this stipulation. Some of them operate only in New Mexico, some of them operate in Texas and New Mexico. I'm certainly concerned about this rate case right now, but I'm also very concerned with what's coming around the corner, especially in light of what SPS just got approved in terms of rate base addition. So I'd like to hear from the parties who've signed this stipulation from a customer point of view. How do they view fairness in a world where they're going to be paying different rates in New Mexico for the same thing that they're paying for in Texas? So if you could help me out with that, hearing examiners, as the hearing goes on, I'd appreciate it. And thank you for your testimony, Ms. Lees. I will not tell your children that you think one of them's no good.
Thank you, Chairman O'Connell. I would also like to recognize that Commissioners Nybert and Aguilera have joined. We are obviously available to take their questions at any time, although they also are free to listen and observe the proceedings as they require. Okay, so we're about 50 minutes into this proceeding so far. On the record, Mr. Lees, are you okay for another 30 minutes?
Judge, if I could have 5 minutes for a bio break, that'd be great.
Okay, why don't we take 10 minutes and then we'll resume with staff's questions. So we'll see everybody back here at 10:30. Thanks, everybody. We are on the record. And the YouTube
Thank you, Judge. I apologize for that.
Mr. Lee, no apologies necessary. We really value and try to organize our time around you and your necessities. So thank you.
All I can say is the mind was willing, but the bladder was weak.
Okay,
ready when you
everybody.
are,
It's yes, thank you, Mr. Lee. So it's just 10:30. So let's resume our proceedings again. We're on the record and on YouTube. Just a bit of a housekeeping. Mr. Elliott is next for cross-examination of Miss Zoe Lees with 55 minutes. That should take us to about 11:30 or so, maybe 11:40. And then at that point, we can go to any redirect from Ms. Hardy, and then anticipate a lunch break around the noon hour for about an hour. So just again, for everybody, situational awareness to keep us on track and on the same page. I believe, Mr. Elliott, you are preparing to cross-examine the witness. Is that correct?
Yes, Mr. Hearing Examiner.
Please proceed, Mr. Elliott.
Thank you. Good morning, Ms. Lees.
Good morning, Mr. Elliott.
I want to ask first, do you know if EPE uses a future test year?
I don't know, Mr. Elliott.
Okay. Ms. Lees, you testified that staff's opposition fundamentally conflicts with New Mexico law and long-standing commission policy favoring settlements, right?
Yes, Mr. Elliott. I believe I testify that staff's opposition does not show that the stipulation is unfair, unjust, unreasonable, or contrary to the public interest.
And the basis for your statement that staff's opposition conflicts with New Mexico law and policies, that staff treats its own direct testimony as, quote, the benchmark for whether the stipulation is reasonable. Is that right?
Yes, Mr. Elliott. My testimony states that staff largely asked the commission to substitute staff's litigation position as stated in its direct testimony for the negotiated compromise reached by the signatories.
So my statement is correct.
It is correct that staff largely asked the commission to substitute its litigation position.
I have a number of questions. I don't mean to speak over you, but if it's correct, just yes or no, please. So you also testified that the approach, staff's approach, is inconsistent with the give and take required to settle a contested rate case. Is that right?
Yes, my testimony states that being unwilling to move off of the position stated in its direct case is inconsistent with that negotiation process.
And so if I understand, your position is that some deviation between settlement and any individual's litigation position, it's not a valid basis for opposing a stipulation. Is that accurate?
The stipulation needs to be evaluated under the state's criteria for evaluating stipulations. Is it fair, just, and reasonable? Is it a product of negotiation between sophisticated parties? Sorry, I'm going to where I list those three factors in my testimony so I can.
I think that's page 9. And avoiding any, violating any important regulatory principle or practice. Is that right? If you remember, just as memory, be great.
Yeah, there's and apologies, Mr. Elliott, I always get a little nervous before I testify, so I like to make sure that I am stating it correctly. But it is whether the stipulation was a product of negotiation among sophisticated parties. The commission cannot approve a stipulation that violates any regulatory principle, or of course can't approve a stipulation that would be violative of the Public Utility Act. And there's one more that I am a second factor that, of course, is the settlement as a whole benefit customers and in the public interest.
So the stipulation has provisions that are interdependent and not severable. And I understand that to mean that the commission can only approve or reject it in its entirety. It can't adopt some provisions and reject others. Is that your understanding?
Yes, sir. My understanding is that the process for which a contested stipulation can go forward is articulated in 1.2.2.20, I believe, is the rule provision. And that is either a stipulation will be certified or it won't be certified.
The hearing examiners have some discretion, don't they, in terms of recommending changes to the stipulation to make it in the public interest?
If you could pull up the rule, I can show you what the provision says, but I believe the hearing examiners may indicate what its issues are with the settlement.
Okay. So when you say the commission's only choice is to approve or reject, you're describing a term that the signatories agreed to demand of the commission. That's not an actual limit on the commission's legal authority to modify a stipulation. Isn't that correct?
Mr. Examiner, I object. Mr. Elliott's really testifying here. There's a long prelude to the question that includes his testimony.
Sure. I would say that I'm asking the witness about her understanding of the stipulation and the law.
Okay, Mr. Elliott, could you rephrase your question and just repeat it and see if that alleviates the objection?
Sure. So the question is, where the stipulation or the test, Miss Lee's testimony that the commission can only approve or reject, that's a description of a provision that the signatories agreed to demand of the commission. It's not a legal requirement or legal limitation on the commission's authority. Correct?
So the commission needs to follow the rule around stipulations and around the process for stipulations and contested stipulations in Rule 1.2.2. I believe the last provision is 0.220. But this represents an agreement among the parties. So if any of the provisions change, then the signatories may not agree to the stipulation anymore.
But you agree the commission does have the authority to modify a stipulation?
This stipulation is up for certification and approval, or the commission could deny the stipulation, could not approve the stipulation, which then my understanding is we would go back to litigate the case.
So the commission cannot modify it to make the stipulation in the public interest as it deems necessary?
If the provisions of the stipulation are modified, then they are materially different than what the signatories agreed to, then there's no longer a stipulation and the signatories have the option of withdrawing from the settlement.
So if one or two of those working groups went away, that would be a modification and the parties could withdraw.
If any term in the stipulation is modified materially, then yes, parties, it's my understanding that the parties could withdraw from the settlement because it would be different than what they agreed to.
So let me, this follows up on Commissioner O'Connell's line of questioning. With respect to the future test years, 62614D, and I believe you addressed this in your testimony, but I'm just going to move on to the question itself. It states that the commission shall set rates based on a test period that the commission determines best reflects expected conditions. And if it's a future test year that the utility has proposed, the commission shall give due consideration to whether it best reflects those conditions. Do you understand that language to give the commission any discretion to evaluate the test period and make modifications if they think it's necessary?
The commission has discretion to evaluate SPS's case and make decisions on the requests in the case.
Can the commission specifically evaluate what best reflects future conditions? Well, let me rephrase that and say, does the commission's discretion to determine what best reflects future conditions extend only to choosing between using a historical or future test year? Is it a binary choice? Or can it look at specific components and adjust those?
The commission needs to evaluate the utility's cost of service and the rate-making decisions made in the stipulation to ensure that they are fair, just, and reasonable. Part of that evaluation is to ensure that they are cost-based and that they follow the Public Utility Act and regulatory principles.
So in your understanding or your opinion, the answer is no?
Objection.
I guess
Ms. Lee's testimony.
Yeah.
Well, I'm confused by the answer. So let me ask the question again.
Mr. Elliott, let's go one at a time. That's very important for our court reporter to understand who's speaking, to understand what the objection is, and also it's critically important for the hearing examiners and the commission to handle the objection. So, Ms. Hardy, what is your objection?
That the question misstated Ms. Lee's testimony.
Okay, so the question was that you're objecting to, Ms. Hardy, is, so in your understanding or your opinion, the answer is no? Is that the question you're objecting to?
Yes.
Okay. And does that misstate your answer, Ms. Lees?
I'm a little bit lost in where we are right now in the questions.
Okay. Well, I think the hearing examiners have the benefit of this real-time transcript that we can look at. So let's go back to your answer, Ms. Lees, before that. And that was the answer that began, the commission needs to evaluate the utility's cost of service and rate-making decisions made in the stipulation, et cetera. Do you remember that answer?
Yes, and I believe I was answering a question of whether the commission can evaluate the components that go in to the cost of service and into the rate making process. And my answer was they can, and these are how they need to do it. These are the parameters under which they do that.
So you're saying that they can, that the commission can?
The commission is charged with evaluating this entire case and determining whether it's just, fair, and reasonable under New Mexico law and well-established regulatory principles.
Okay, so I'll sustain the objection, and Mr. Elliott, you may proceed.
Okay, thank you. Ms. Lees, I want to talk about your testimony on page 28 of your
Mr. Elliott,
rebuttal?
which testimony? Rebuttal.
Yep. And specifically, you say that in a regulated monopoly, rates are not determined by ordinary market competition. Do you see that starting at, it's the first paragraph, 1 through 8. And my question to you is, specifically at lines 5 through 8, you say a negotiated settlement among sophisticated parties with adverse interests can serve an important function by testing the utility's request, forcing concessions, and so forth. Do you see that?
Yes, sir.
Is it your position that the settlement negotiation itself is what tests the utility's request and forces concessions? Is that a fair characterization of your testimony?
There's two options. It's either a litigated rate case that tests the utility's request, or that can also be done in this negotiated settlement process as well.
So if you're in the negotiated settlement process, what's your understanding of the commission's role and staff's role?
Well, the commission's role is to evaluate the settlement as a whole and determine whether it is a product of negotiation among sophisticated parties representing diverse interests, whether it benefits customers and the public interest, and whether or not it violates a regulatory principle or the Public Utility Act. Staff's role is to represent the public interest in these proceedings.
And this is what you described as in a regulated monopoly, rates are not determined by ordinary market competition. Instead, the regulatory process stands in for competition. Those are the two processes?
Yes, sir. The regulatory process stands in for market competition for regulated utilities, regulated monopoly utilities.
So if the regulatory process substitutes for competition, and it includes provisions for contested stipulations under 1.2.2b, then isn't staff's opposition and this cross-examination part of that process that stands in for market competition?
Certainly the hearing process is part of the regulatory process that stands in for competition.
So when you argue that the commission should defer to the signatory's negotiated result because negotiation stands in for competition, aren't you essentially cabining the commission's discretion to review and determine what is in the public interest?
No, sir.
Explain, please.
The commission has the opportunity to evaluate this settlement, and it must do so according to those three factors. It is my testimony that we meet those three factors. It is the commission's job to determine whether or not we met those three factors.
So if it finds that so if it's evaluating the stipulation as a whole, it can't look at specific provisions and modify them.
The factors contemplate that the commission evaluate the stipulation as a whole.
Okay. You testify that the stipulation as a whole benefits customers and the public interest. Under the stipulation, residential and small general classes see base rate increases of approximately 17.5%. Is that right?
Yes, sir. I believe it's approximately 17.5%.
And under staff's litigation position, residential customers would see average bill impact of 6.3%. Is that right?
Subject to check. It sounds right.
Okay. And the stipulation result for those same customers would be about 13.6%. Is that right?
Yes, sir.
Okay. And you point to the NMDOJ support for the settlement as a favorable compromise for residential customers. Is that right?
Certainly, the New Mexico Department of Justice represents residential and small business customers and was a signatory to this agreement, believing it was in the public interest, fair, just, and reasonable.
Can the commission still evaluate that claim?
Yes, sir. We're in a contested hearing today so that the commission has the evidence it needs in order to evaluate the stipulation.
Would we be here if this wasn't a contested stipulation? Would these questions be asked?
I don't know, sir. I have been in many hearings on non-contested stipulations.
I guess let me just check here my notes. I have approximately 38 minutes left, I think. Mr. Hearing Examiner, would I be able to reserve this time and shift it to another witness if necessary?
That's no problem, Mr. Elliott. We routinely allow the parties to contribute time to another witness.
Ms. Lees, there was one other question I had. It was about, let me just make sure I can find it. I believe it was footnote 6.
May I ask which? Okay. Can I please have a page number, Mr. Elliott?
Yeah. Yes. Just one moment. So many pieces of testimony.
I believe it's on page 15 of my rebuttal testimony, Mr. Elliott.
Yeah, that is not the one that I'm looking for. So I've misplaced it. This was about an EIA calculation. So put it in the parking lot. If I don't find it right away, I don't. All right. Thank you, Ms. Lees. I appreciate your time this morning.
Thank you, Mr. Elliott.
Okay.
Thank you, Mr. Elliott. There's 32 minutes remaining on your time for Ms. Lees. Do you know which witness you would like to allocate those minutes to at this point?
I don't. I just would request
No,
a bank.
no rush. No problem. I'll just make a note. Let's both of us make a note here for our record that you have that time remaining, 32 minutes.
Okay. Thank you.
Thank you, Mr. Elliott. Ms. Hardy, do you have any redirect for Ms. Lees?
I do not. Thank you.
Thank you, Ms. Hardy. So I don't believe anybody else reserved time to cross-examine Ms. Lees. So at this point, again, I just remind everybody that Commissioners Aguilera and Nybert may have questions, so we will be attentive to that. But in the meantime, I will defer here to Hearing Examiner Getco to see if he has any questions for Ms. Lees.
Thank you, Hearing Examiner Schaefer. I do have some questions, and given questions that have already been asked and covered, it may take me some time to make sure I don't duplicate. So I ask for some grace from all parties with respect to that. So following up a little bit on some questions that have been asked, Ms. Lees, the last piece that you identified with respect to the question before the commission is whether the stipulation as a whole, et cetera, was whether it benefits customers and the public interest. And I believe, did you say that would staff's direct testimony present a position that staff believed was in the public interest when they filed that testimony?
I'm sure it does, Hearing Examiner Getco.
Okay, thank you. So you referred to Ms. Johnson's rebuttal testimony, and in particular, there's a table there, AMJ-STIP-R1, and it
Mr. Hearing
summarizes.
Examiner, can you
Yes.
just give me an indication of where you are in my testimony so I can follow the question?
At 13 to 15, I believe it is, in your rebuttal testimony and support. I can go there for where you reference it. I didn't do that as I normally do because it was really a reference to Ms. Johnson's testimony. I can do a search really quick.
I believe it's on page 29, okay. Mr. Hearing Examiner.
Thank you. So it's referencing a table which summarizes the principal revenue requirement adjustments reflected in the stipulation. And so my question was, and is, if a particular figure there doesn't appear, the commission determines, or the hearing examiners, let's start with the hearing examiners. If the hearing examiners determine that a particular figure there isn't in the public interest, the consumer interest, or the investor interest, which are all referenced in the statute as being tasks for the advisory staff of the commission, not the advisory, the adjudicatory staff to represent. Then what am I supposed to do as a hearing examiner, as a more open question? Not asking for your legal opinion, but what your expectation is as the regional vice president.
My expectation, Hearing Examiner Getco, is that you would follow the provisions of the rule 1.2.2.20, I believe, that provides the process for certifying stipulations, whether they are contested or not.
And so going to that rule under 1.2.2.25a.
25, thank you.
No, it's 20.5a. You were correct. You were correct.
Okay. I don't have that rule in front of me, so it might be helpful to share the screen. Hearing Examiner Getco.
I think it might be a little bit easier just to read that one. It's not that difficult. So 5A says, 5 says, in cases heard by a hearing examiner rather than the commission, the hearing examiner may. And then A is decide that the settlement stipulation should not be certified to the commission at all, comma, in which event the hearing examiner may indicate to the parties and staff whether additional evidence or legal argument in support of the stipulation or amendments to the stipulation might meet the hearing examiner's reservations about the stipulation. Do you interpret that to provide an opportunity for the stipulation to be revised by the signatories and represented through some manner of disposition? Or is it a limitation that further evidence and legal argument only be provided on the strict terms of the stipulation as it was originally submitted?
Hearing examiner Getco, I think that provision provides the hearing examiners an opportunity to let parties know what additional evidence is needed and gives the parties an opportunity to go back and either present that additional evidence or revisit the stipulation if that's what's required to address the hearing examiner's concerns.
So the reference there to indicate amendments to the stipulation that might meet the hearing examiner's reservations would present an opportunity for the signatories to amend the stipulation. Is that correct?
I believe so, hearing examiner Getco. Do you mind giving me time so that I can search for the rule and pull it up just to look at it? I get nervous answering questions when I don't have a rule in front of me.
I understand. I'm sorry for pushing forward. It's just that I had so many windows open that I didn't really.
I totally get that. That happens to me too.
Do you see my screen now?
It's loading still, sir. If you could zoom in, please. It's very small on my screen. Okay. Yes, sir. I do believe
Excuse me,
that
let me interrupt. Hearing examiner Getco, can you hear me?
Yes.
Okay, my audio just went out. I can hear the parties, but at a very low level. So I'm just going to log out and log back in, and hopefully that resolves the issue. Just give me
Okay.
just
Everybody, we're
one
going to just
second.
take a slight pause here and wait for hearing examiner Schaefer to log out and log back in, and then we'll see if the issue is corrected. We'll just pause. Hearing examiner Schaefer, welcome back. I'm speaking to try to give you a test of whether you can hear me, and then we can turn to a witness and see whether you can hear a witness. I'm going to stop sharing my screen so that I can use other methods to communicate with hearing examiner Schaefer, everybody. We're going to go ahead and just take a 5-minute recess. We might be on the YouTube. Everybody should understand that it'll still be on. But we're in recess
Actually,
until.
Examiner Gecko, it's working again.
Okay, excellent.
I'm not sure, but let's proceed. Thank you.
Okay.
Would you like me to test my audio? Hearing Examiner Schaefer, can you hear it?
No, it's working. Everybody's working now. It's just for some reason the volume went to a very, very low level. So, but I'm happy to say that all systems go. Thank you, Ms. Lees.
Thank you. And Miss Lees, I'm sorry, I'm trying to go back a little bit to see where we left off. So I had asked, and I'm going to share my screen again.
Yeah.
Okay, do you see the rule 1.2.2.20 on your screen again, Miss Lees?
No, sir. No, sir. I don't.
Okay.
Something
Do
is
you now?
loading.
All right, great.
It's not up yet, but it's loading.
Great.
Yes, I see it now.
And so in 5A, the question was essentially the hearing examiners would have an opportunity to indicate amendments to the stipulation that might meet the hearing examiner's reservations. And so a fair understanding of that is that procedure could be handled in a way so that the signatories to the stipulation could submit amendments to the stipulation for further consideration by the hearing examiners and the commission. Would you agree with that understanding?
Yes, Hearing Examiner Gedko, my expectation would be that should the hearing examiners find that the settlement stipulation should not be certified and were to make the indications in that this provision contemplates that there would be a procedural conference and that the attorneys and the hearing examiners would work out the procedure for going forward.
Okay, thank you for that. I'm going to stop sharing my screen then. And then get everything back to where it was. Okay. So I want to turn to page 9 of your rebuttal testimony in support of the stipulation at lines 11 through 14. And are you there?
I am, sir. I was just reading 11 through 14.
And so for the party's benefit, and this is one sentence, so I'm going to take the liberty to read it. You state that SPS is serving significant growth in New Mexico, and the commission should not adopt an approach that would preclude SPS from making the infrastructure investments needed to serve that growth. My question is, how would an approach taken by the commission preclude SPS from making the infrastructure investments? And I ask that with the context of, well, first I'll just ask it open-ended. What would preclude SPS from making the infrastructure investments needed to serve that growth?
Hearing Examiner Gecko, the The rate making decisions in this proceeding should be cost-based and should be pursuant to the Public Utility Act and not violative of any regulatory principle. Deviating from those would result, in my opinion, in unjust and unreasonable rates. And unjust and unreasonable rates would make it very difficult for SPS going forward.
The stipulation does contain proposed rates, though, that don't follow a strict class cost of service study. There's banding and taken into account and such, correct?
Yes, there are compromises in the stipulation in terms of allocation of costs to customers that are reflected there and are the result of a negotiated process.
Okay.
And as
those
Ms.
negotiations wouldn't preclude investments, would they?
I'm
No,
sorry,
sir.
those negotiations wouldn't preclude.
I apologize. I should rephrase. Thank you. The parameters in the stipulation wouldn't prevent the investment that SPS needs to make, would they, Ms. Lees?
No, hearing examiner Gecko. SPS believes that the provisions in the stipulation and the stipulation as a whole result in just, reasonable, and fair rates.
Okay, thank you. Did SPS participate in some amount, a minimum, one meeting per chance regarding possible stipulation with every party in this proceeding?
Yes, hearing examiner Gecko, as articulated in my direct testimony in support of the stipulation, SPS met with all parties in this case many times regarding the negotiations and the stipulation. All parties were invited to the negotiation conferences, the settlement conferences, and SPS also met with parties separately. The parties also met among each other without SPS.
Okay, thank you. In your experience, have you you've participated in lots of settlement negotiations, correct?
I have participated in settlement negotiations in the past, yes, sir.
And have you ever been in other cases? Have you been in cases where a party participates for a certain time period and then makes a decision not to continue participation?
At this time, hearing examiner, I can't remember a case in which that happened. I'm not saying it hasn't, I just can't remember as I sit here today.
Okay. I'm just going through some questions that I no longer need to answer, just to provide some context. Okay, I'm going to move on to a couple questions about a little bit different angle. So, are you familiar with, there's testimony from staff witness Zigich. This would be his direct testimony, I believe, where he speaks of issuing discovery and then that SPS responded on February 26th, 2026, that they did not possess responsive materials to the request. And then he testified to on March, that same day, the commission issued a pre-hearing bench request, which included a similar request for 440 report information, and that SPS submitted supplemental testimony, including supplemental testimony of Michael Keatsman. Am I saying that correctly? Michael Keatsman with that spelling, or is it Michelle? I apologize.
It's Michelle.
Michelle, thank you. I've heard both. That provides much of the information originally sought by staff. So with that as a little bit of context, there's a general understanding that SPS is under pressure to bring new resources onto its system, and therefore timelines are important. And is it correct to say that in case number 25-00066-UT, SPS requested expedited treatment with respect to the CCN statute allowing 9 months with an extension of 6 months, and requested that it be that an order be issued within 6 months?
Yes, sir, that's correct. We made that request.
And so if things are to move quickly through, then would it be helpful if discovery is issued in a reasonable manner, and if the same questions are asked by a party as the commission might ask, that SPS would provide that information to the best of its ability?
Certainly, sir. And without having the discovery request and the bench request in front of me, I can't evaluate kind of what those requests were, but it is it's reasonable to expect that parties will respond to discovery with the information that it has.
Okay. And that's what Rule 1.2.2.25 states. It says, commission policy, the commission favors prompt and complete disclosure and exchange of information, and encourages informal arrangements among the parties and staff for this exchange. Does that sound like good commission policy to you?
Certainly, hearing examiner get-go, and we always try to make ourselves available to answer parties' questions about the case and have informal conferences, or technical conferences is what we call them, to get our experts together should parties have questions about the case. We did that in the settlement negotiation process. If parties had questions about certain provisions, we were able to get our experts together so that they could explore and discuss and answer questions.
Okay. Great. Thank you. And I'm going to move on to another topic then. So in your rebuttal testimony in support of the stipulation at page 61, lines 1 through 2, and I'll go there as well. You state that mechanisms, and this is in the context of rate case expenses, and you state that mechanisms are available to address staff's concerns, and those staff's concerns are testimony as to whether the stipulated amount of rate case expenses are in the public interest or should be certified. Their mechanisms are available to address staff's concerns, such as a true-up or tracker, but no party requested such a mechanism in the settlement process. So right now, in this case, the rate case expenses are based upon estimates, correct?
I believe we also have provided invoices to support some of those rate case expenses as well. And then there is taken into consideration the rate case expenses that we will incur to put on the hearing, to do briefing, things like that.
Are those invoices in the record? I'm sorry, I didn't locate those. I thought it was something that was referenced as being in discovery, but not being submitted into the record.
Off the top of my head, Mr. Hearing Examiner, it would take me a minute to figure out if they're in the record or if it was just discovery responses.
Okay. So with reference to, and you know, your testimony spoke to this too, of you even state that you provide caution that much of the actual rate case expense is incurred in the later stages of the case, just before, during, and after the public hearing. And so a great portion of the actual expenses will not be known at the time that this case proceeds to hearing. Given that reality, how would it work if the commission wanted to have SPS charge for actual rate case expenses?
Again, there's a number of mechanisms that can be used, such as a true up or a tracker. How that would mechanically work, I would defer to Mr. Trowbridge to talk about how that would mechanically work in rates. But those mechanisms have been used in the past.
Have they been used in the past in New Mexico that you're aware of?
I don't know, sir.
Are you familiar with how it works somewhere else then, that you have a recollection of how it's been used in the past?
True-up mechanisms have been used to ensure that costs recovered from customers reflect the actual costs. So, for example, in Texas, in the GCRR, there's a true-up process in a rate case. After the costs from the GCRR roll into the rate case, there's a true-up to ensure that the company has recovered its actual costs for those infrastructure investments and have it over or under.
You know, given the voluminous testimony in the case regarding cost causation, and you know, the fact that you address the possibility of this, and you state that no party requested such a mechanism, is there a reason that SPS didn't request such a mechanism, such as a tracker to get to actual rate case expenses?
Yep. SPS believes that the amount articulated in the settlement for rate case expenses are just and reasonable and reflect the rate case expenses that will be incurred for this case. And the signatories agreed that it was a just and reasonable amount of rate case expenses to be recovered.
Thank you. And I'm looking for one other piece here.
I guess certainly if those rate case expenses exceed that number because of the litigated nature of this stipulation hearing and process following it, those rate case expenses are capped at what is articulated in the provision of the settlement.
And my concern was a little bit in the, you know, it's just with cost causation, and I'm not finding the quote immediately, it's here, but that the estimates provided by SPS in the rate case application take into account motions for rehearing, you know, exceptions, etc., steps to the process that may not occur. And so in cases such as that, Um, is the is it the expectation that the commission should understand that the estimate that was provided and the stipulated amount is within dollars of what was in the original application? Um, am I misunderstanding that, you know, is there something in this process that would say that at this point, if this were recertified and we were to finish, that we would still accrue all those costs, even if there weren't excessive procedural necessities that followed after the issuance of a certification?
I'm not sure I'm understanding your question, hearing examiner, but certainly because this is a contested stipulation, and that it's taking a more litigated path, SPS is incurring legal fees that it would not otherwise incur had it been a non-litigated stipulation.
And being that I don't have a history of it either, and if the commission, or if the hearing examiners did want to see invoices that took into account, what would be the delay in that process? Like what kind of timeline would the commission be looking at?
I don't know, Commissioner Getco. I think the hearing examiners certainly have the ability to issue bench requests if they choose to, and SPS will endeavor to respond to those bench requests by the deadline that the hearing examiner set, and will let the hearing examiners know whether we need more time for that deadline in order to be responsive. I think that's kind of our practice in hearings.
Okay. Yeah, I was thinking more in the terms of kind of like monthly billing, but I imagine there's exceptions. Okay. This is just a curiosity, and it comes from in your direct testimony on page 96, 3 to 4, lines 3 and 4. You reference some knowledge there with respect to Colorado Public Utilities Commission and property tax tracker.
Yes, sir.
And it just indicated to me that you have some knowledge, given that Colorado Public Utilities Commission is part of the Excel system, about Colorado and what occurs there. Some knowledge. Is that
yes, this
fair?
question and answer provides what I know that the Colorado Public Utility Commission allows in terms of a symmetrical property tax expense tracker.
So that just prompts me to ask, do you have any familiarity with Colorado law that exists for symmetry of legal and expert witness fees between a utility and parties? I was able to Google a little bit about it, and I've always been curious. And given your knowledge, do you have any knowledge with respect to that?
I don't, Your Honor.
Just going through. Okay. So, and I don't know if we need to turn to the, well, we can go there. It doesn't hurt. In your direct testimony at page 65, lines 12 through 15,
Yes, sir.
And this is direct testimony. You stated that SPS request authority to establish a regulatory asset to accrue with interest at the WAC, at its WAC established in this case, WAC being the weighted average cost of capital, Mr. Lee. I believe I said that right. Any appellate rate case expenses incurred as part of an appeal of this case. So my question then turns to the stipulation has a provision for a 2-year amortization of rate case expenses. Does the stipulation, is the agreement that would there be any accruing interest on the rate case fees that are being collected through that 2-year amortization process that's established in the stipulation?
Well, the stipulated amount would be recovered through base rates over a 2-year amortization period.
And so you would apply the WAC to that amount through base rates.
That's not stipulated to in the agreement. Ms. Johnson can talk about what, if any, return is applied to this, but my understanding, and Ms. Johnson can confirm, is that if it's in base rates, the ROE is applying to those costs while they're in base rates. But Ms. Johnson can confirm that.
Okay. And given that it's amortized over a relatively short period when we compare it to, large resources that go between 20 and 40 years, for example, and the stipulation, setting a long-term cost of debt for recovery of production tax credits that you haven't been able to cash out yet. Do you think it's appropriate that for something that's over 2 years it receive the WAC, or would it be reasonable perhaps to have a lower rate of return on an asset that's amortized over 2 years?
I think that the provision in the stipulation is fair, just, and reasonable, Mr. Gitko.
Can you explain why it's fair that a 2-year amortization receives
well,
WAC? Just
so
I've seen it and I've seen it approved, but it would help me to understand, how that gets done, because it's obviously negotiated. And sometimes it ends at the long-term debt, and sometimes there's short-term debt. And so what's the reasoning there that makes that fair, just, and reasonable?
The provision 1.10 in the stipulation, in my opinion, is fair, just, and reasonable because it allows SPS to recover its rate costs for rate case costs for regulatory proceedings that it is required to participate in. But it spreads those costs over 2 years instead of having customers pay for them all at once. But it also matches more closely to have recovery from customers that match in time when those costs were incurred. So you're not spreading those costs over a longer period of time, maybe not matching the time period for which they were occurring, having customers pay for things that occurred too far in the past.
But if I applied a different carrying cost on that and still set it at 2 years, we'd still accomplish that goal of having the actual ratepayers that incurred that cost pay for that cost, correct?
Yes, I guess I was alluding to the amortization period in my answer.
Okay. This is something that I don't know. If there's an appeal and SPS loses the appeal, are those expenses also understood to be able to be charged to ratepayers through base rates?
This stipulation does not contemplate that, Mr. Hearing Examiner.
Do you have an understanding of that?
The commission would have to approve, obviously, such a request, but the SPS is not requested to recover those types of costs in this stipulation. And the signatories did not agree to it in the stipulation.
Okay, so is it your testimony then, and sorry, I'm trying to follow here, that rate case expenses, the recoverability of rate case expenses, including appellate expenses, must be granted by the commission? Or is it your position that it has been established law that you have a right, that SPS has a right to recover those expenses? You reference a Supreme Court case in your testimony.
My apologies, Hearing Examiner. I was trying to answer your questions as it pertains to the provisions in the stipulation. I guess if we're going to take a wider view of what SPS originally requested in the case, the request was that if a party appealed a commission's decision and SPS entered into that appeal to support the commission's decision, it was going to request authority to establish a regulatory asset to accrue with interest at its WACC established in this case, any appellate rate case expenses incurred as part of that appeal. Now, and maybe I was just confused on the questions you were asking, but the stipulation itself, the only agreement is on the number in the stipulation for which SPS will recover rate case expenses. It's my understanding, if the stipulation is certified by hearing examiners and approved by the commission, that I don't expect that we would be in a position where we would be entering our appearance in an appeal.
If there were an appeal, let's say the stipulation breaks down, hypothetical, and they're an appeal, and SPS didn't, and SPS brought the appeal. Would SPS need to receive approval for appellate fees, or is it your understanding that SPS has the right to recover those appellate fees?
Hearing Examiner Gecko, the utility always has to request authority to recover its rate case expenses, whether those include appellate fees or not.
Okay, thank you.
And apologies if I was getting confused by your questions, but I think I understood in the end what you were asking.
I think you're doing an excellent job working with me. I mean, I have different questions up here, and I try not to waste time with stuff that's been asked, but sometimes that leads to a question not being perfectly clear. So I appreciate you working with me on it. Then I want to turn to your direct testimony on page 53, lines 4 through 9. And you make reference there. Are you there?
I am, Hearing Examiner Gecko. I'm reading the lines that you referenced.
Okay.
Yes, sir.
And in this discussion of, rate case expenses and other regulatory expenses for which SPS seeks recovery, you reference prior rate related matters. I took a little look at the exhibit that you provided, attachment ZEL-7, and there's a reference there to, I think, an RFP case and another case, but SPS has lots of cases. So I'm kind of wondering what is your understanding of prior rate related matters, and which of those can SPS seek recovery for in relation to a rate case expense?
So SPS lists the prior matters on lines 9 through 11. And then this section of my testimony also addresses those. Give me just a second. So on page 66
of your direct testimony, correct?
My direct testimony, yes, sir. It identifies that SPS incurred a total of approximately $110,000 of rate case expenses in its standby rate rider proceeding, and that we are requesting recovery of that as well. And then in the IRP, we seek recovery of certain costs. For the commission-approved independent monitor.
And I think the independent monitor is covered by rule. But I don't know if we need that kind of detail. My question is a little bit more of whether there's like a logic that exists in what you include as prior rate-related matters that you submit as an expense for recovery when you file a rate case.
In general, I testify to it in my direct testimony, but it is cases in which we were required to make those filings or to use a regulatory process that's mandated by the commission. And that's how we were determining whether we would include those costs or not.
Okay. And, is there a reason that you haven't included costs from REA plan filings, for example, or LTPPA filings that include resources that result in rates that ratepayers pay? I'm just curious.
So in the Renewable Energy Act filings, we do include, at least we did the last time I was a witness in the REA filing, we do include a request to recover our rate case expenses through the rider.
And with LTPPAs, do you do that as well? It's like maybe I'm seeing a logic of like cases that don't already include requests for legal and expert fees, are what get included in rate cases, for example. That's why I'm just saying, okay, that's excellent information regarding the REA plan filing, and wonder if that applies to LTPPA filings as well.
So requests for approval of PPAs, Hearing Examiner Getco, I'm not remembering how we handle those requests in those filings.
Okay. And are you familiar with it beyond, that they were matters, I believe you said, and I'll paraphrase here, that, SPS was required to file? Was there any additional logic to the cases that were chosen to be included in the rate case expenses that were filed for in this application, and that amount was agreed to stipulation?
Yes, sir. We do take into account New Mexico law and precedent. I believe I discussed that around page 54 of my direct testimony, in which it has been found to be reasonable and prudent for a utility to recover its expenses, and utilities should generally be allowed to recover their expenses for participating in the required regulatory process.
Okay, thank you.
It's part of the cost of service to our customers to participate in that process.
Okay. Okay, thank you. On a little bit different angle, there's testimony and indirect testimony regarding the amortization period. And, a concern is, here's the concern, we don't need a reference, of if new rates don't go into effect through the next rate case in 2 years, and for example, situations arrive where another rate case isn't filed for 3 years, and maybe those rates go into effect 4 years after the conclusion of the rates going into effect from this case, that a 2-year amortization would create an amortization expense that would be repeated in years 3 and 4. And by my understanding, could create what some folks might understand to be an over recovery of rate case expenses. And so therefore it might be more reasonable to choose 3 or 4 years. And with the context that there's an agreement in the stipulation that any rate case expenses that haven't been recovered by the time that new rates go into effect, SPS reserves the right to seek those rates in the next rate case. So what I see that as doing is, tell me if I'm wrong, that stipulation provision eliminates the risk of SPS not recovering those rate case expenses, assuming they'd be approved in the next rate case, but creates a risk that SPS might over recover those rate case expenses. Is that a fair understanding of what might occur if new rates did not go into effect within 2 years, within the, right in the amortization period of 2 years for these rate case expenses?
Hearing Examiner Getko, this provision only allows SPS to recover the rate case expense over a 2-year period. So once the 2-year period has completed, the stipulation doesn't authorize SPS to continue recovering those costs. So I don't know I don't believe that risk is present here because the parties have stipulated that we may recover these costs over a 2-year period.
Okay, so your answer really helps me understand something I don't understand. I see a future test year as a snapshot in time. The expenses that are included in that snapshot get repeated ad infinitum until new rates are set. And so I had an understanding that it would set an amortization expense of, we'll just say approximately $2 million. And that would be established in base rates. That would be a piece of it. And so there I thought, okay, that $2 million gets collected in year 1 because we collect what's determined by the snapshot. It gets collected in year 2. Those rates are set. Those rates are still in effect, base rates in year 3. What am I not understanding about amortization? If we can only collect up to the full amount of what those rate case expenses are, is there something I'm missing in my understanding of rate making and how it works, where those rates can change to pull out what those expenses are without the use of a rider or a true up?
So SPS witness Allison Johnson can kind of explain the mechanics of how it works. But what I can say from a policy level is that the parties agreed to this stipulation, and by SPS signing on to this stipulation, it is agreeing to only recover these costs over a 2-year period and not to extend that period past the 2 years. I will also say, hearing examiner Gecko, given the infrastructure investment that SPS must make to continue to serve its customers, allow for growth and reliable utility service, SPS will be coming in for another rate case, likely next year. So I'm not sure that the concern about SPS staying out for a long period is present.
I understand that, but things happen. I appreciate that. Okay, I'll note it, and I appreciate that clarification. And I'll try to, I made a note to visit that with Miss Johnson. The next topic I have here in Examiner Schaefer, I think is going to take more than 10 minutes. I have questions about production tax credits and the recovery of those and how that functions. And so I don't know if now might be a time that we want to take a lunch break or whether we want to do that later.
Yeah, I think it's good to take a break right now. We've had I think, a very productive morning. So why don't we all meet back here at 1 p.m. That'll give us just about an hour for lunch. And thank you again, everybody. Now remember, we're still streaming on YouTube, so make sure to mute your mic and close your video unless you want to be streamed. Okay, we'll reconvene at 1 o'clock. Thank you, everybody.
Zoe? Yeah, it's going on.
Mr. Lee.
Good afternoon, Judge.
And then perfect timing. Hello, Miss Lees.
Mr. Hearing Examiner, before we get started, Miss Lynch is in the waiting room.
Thank you. And so is Mr. Vondrasek.
I just admitted them.
Excellent.
I'm ready when you are, Judge.
Excellent. Thank you, Mr. Lee. Welcome back, everybody. Good afternoon. Looks like Mr. Rhodey is joining here just at the 1 o'clock hour. Let's go ahead and resume our proceeding. I think we're making good progress. Just before we get back to hearing examiner Getco, Ms. Hardy, who are you thinking about calling after Ms. Lees, just for some note keeping?
Ms. Keatsman, Mr. Examiner.
Okay. Thank you, Ms. Hardy. Okay, are there any other questions or procedural matters we need to address before we get started again?
Mr. Examiner?
Yes.
Once we go back on the record, Ms. Lees had a clarification that she wanted to provide regarding her response to hearing examiner Getco's questions on rate case expenses.
Before we go back on the record?
No, once we go back on.
Oh, okay. Okay, sure.
Thank you.
Okay, well, let's do it. We're back on the record. Ms. Lees, the floor is yours.
Thank you, hearing examiner Schaefer. Do I need to wait for my attorney to ask me a question and then respond to it? Or, I'm sorry, I just want to make sure we do this procedurally correctly. Yeah.
Go ahead, hearing examiner Getco.
Ms. Lees, please go ahead with any clarifications that you want to make right here regarding the testimony that you've provided thus far today. Thank you.
Thank you, hearing examiner Getco. The clarifications I have are on provision 1.10, rate case expenses. You asked me a number of questions about those. I over the break realized that some of my testimony was incorrect. First, SPS does not earn a return on rate case expenses. And second, the treatment that I described in my testimony is not how those expenses are treated in base rates. And as I stated in my testimony, Ms. Johnson is the right witness to ask about how rate case expenses, once put into base rates, are treated.
Thank you, Ms. Lees. Given that clarification, and we'll just put it in terms of a hypothetical, if collection of the rate case expenses had the possibility to result in collection through rates that exceeds the amount stipulated to in the stipulation, would you maintain that SPS has any right to recover rate case expenses that exceed what is in the stipulation?
Hearing examiner Getco, the stipulation states the amount of rate case expenses that can go into base rates, and that it is my testimony that that is the amount that is just and reasonable to be included.
Okay, that didn't quite answer the question.
Okay.
Would you go on record as saying that SPS will commit to not collecting $1 more than what's been stipulated to in the rate case for rate case expenses in the stipulation?
My testimony, Mr. Getko, is that the provision provided in the agreements provided in provision 1.10 and agreed to by the signatories are just and reasonable. Ms. Johnson can explain how those will be treated in base rates. And the commission, of course, has the ability to examine that provision and in evaluating it as part of the entire stipulation, determine whether that is just and reasonable.
You know, this is the classic dance. So I asked, and you're testifying right now, so I understand that you've given testimony, and that's why I'm asking for additional testimony, because the information that's in the written testimony that's been filed, I believe, needs a little bit of clarification. And so, is it SPS's position that the stipulation might contain a provision that could result in SPS recovering an amount of rate case expenses that are greater than the amount that is listed in the stipulation as being stipulated to?
No, hearing examiner Getko, and Ms. Johnson can explain how this provision will work functionally in rates.
Okay. Okay, thank you. Thank you. I similarly have one topic that I want to return to just very slightly, because I didn't have a document well notated when I was dealing with it before. And this is a bit of a paraphrase probably, but I understood you to speak in your testimony before lunch to the efforts that SPS makes during the rate case process and leading up to it to meet with parties that may intervene in that rate case and commission staff and would you include in that you try to make efforts to develop understandings of ideal ways for testimony to be submitted, tables, charts, etc., so that they can be well understood by the parties?
Certainly, we are open to feedback from any intervener or party that has feedback on what we can do to provide a clear application and initial filing. Hearing examiner Getko. And we take that into consideration as we try and meet our burden of proof in our initial filing.
Okay, and I raise it only because you spoke to that, because of the investments that you're making, there'll be another rate case filing, and so kind of in line with the questions from the chairman today of talking about groups getting together and meeting, and is there just listening? Is there product that comes out of that? I want to turn. You may not have it accessible, but there's testimony by staff witness Darren Zigich. Do you have his direct testimony available to you?
Yes, it will take me a moment, hearing examiner, to pull it up.
Thank you.
And just for clarification, hearing examiner Getko, are you talking about the direct testimony or direct testimony in opposition of the stipulation?
The original direct testimony, yes.
Okay, sir, I have it.
Okay, on page 13, lines 8 through 17, witness Zigich, this is in a discussion with respect to Rule 440 filings and also the application of Rule 580 and the work that he does as an expert for the commission for commission staff to reconcile those filings and understand and keep track. And what he says there is he says staff does highlight that SPS has provided very little scope and justification information for each individual project. And then because SPS witness Heffington used to work for PNM and supplied testimony for them, he says a comparison of SPS witness Heffington's direct testimony and attachments are more difficult to review and provide less granular project-specific information than the same individual supplied as a PNM witness in case 2400089-UT. I fully understand that there's differences between utilities, but I see it, I raise it for, you stated that you're open to hearing feedback. Would you see it as useful for SPS, since you are going to imminently file a rate case, to proactively schedule a meeting with commission staff experts for understanding what changes might be able to be made so that everybody can be efficient in the process?
Certainly, Hearing Examiner Gecko and SPS is willing to do that should staff seek and desire to do that with us ahead of filing another base rate case.
Okay. Since SPS understands its timing better than staff as far as the development of a rate case goes, what I just heard there is that you would say you'd be open to it if staff would reach out to SPS. Would you commit to reaching out to?
I'm sorry if there was confusion. We will reach out and are happy to have that engagement with staff should they desire to have that meeting with us, of course.
All right, great. I figured we'd all be on the same page. Sometimes it's worth discussing these things and bringing up particular examples, and because both of you are distinguished professionals. So.
And we meet with staff on a fairly regular basis. We try to keep them updated on what's going on with our filings, future filings, and our plans so that they can manage their workload as well. So I think that is something that we can fit very easily into the regular cadence of our meetings with staff and the outreach that we have with them.
Great, thank you. And I'm sure other parties would ultimately, and you've already spoken to this, I imagine they would want inclusion. They may have ideas about that as well, but I'll leave that to you and staff. Okay, turning to the next one. Now we're done revisiting topics from the morning so far. Okay. Okay, I have some questions and I'm going to clean up what's open on PDFs. Regarding stipulation provision 1.8.a, which is on page 7 of the stipulation. And that provision establishes that SPS may earn a return at the cost of long-term debt through its FPP CAC on its deferred tax asset associated with production tax credits, also known as PTCs, created by Plant X Solar, Cunningham 1 Solar, and Cunningham 2 Solar. Collectively, the SPS solar projects, to the extent those PTCs are unused or not yet transferred. And so a concern in my mind, and I located it in previous cases as well, was that if there's a return on the PTC, here it's been agreed to on the long-term debt, that over a number of years, if the PTC is not transferred or cashed out, that term is used in this case a little bit, there could be an incremental amount of essentially accrued costs for that PTC that gets charged to ratepayers. Just on that basic premise, if let's say the PTC is not cashed out and it stays in rates for a year, it's proper to understand that there's going to be a cost, an interest cost applied to that that's charged to ratepayers at the rate of long-term debt, correct? Is that right?
If the PTCs aren't transferred, yes, but in this case, we're talking about, it's my understanding that these are relatively like short in time transactions. Ms. Johnson can talk about what that deferred tax asset, the total of that is. My understanding is it's very low, around $500,000, and we're talking more about just managing the timing difference between providing the benefit of the credits to our customers through the FPP CAC in real time, and then managing that slight timing difference on when we realize the cash values of those.
Okay.
And Ms. Johnson can talk about how that functionally works.
Okay. And this was from prior cases, does SPS have any incentive to not sell those tax credits and instead allow them to accrue carrying costs in the deferred tax asset?
You may need to talk to Miss Naomi Koch about just how that market works. I am not familiar with under what circumstances we would not sell a production tax credit or transfer a production tax credit, although I do know that we would always analyze whether it's better to transfer those or hold them to offset a tax liability in the future. So there's a couple options we have for those tax credits that we need to decide on how to treat them. I do want to say Ms. Koch can speak to that, but the market is a negotiated market, so we may have to go into closed session if you have questions with her about that, just because we wouldn't want to provide any information to buyers or sellers in that market that they wouldn't already have.
I'm taking a couple notes here. Well, I'm going to trust you to tell me if an answer requires closed session. I'll do my
Ms.
best.
Koch can identify that. I can't really testify to how this functionally works on that market side of things. I don't know.
Do you have a general enough knowledge to make a statement as to the longest time period that you have held the production tax credit? And
I don't. Oh, sorry. Go ahead.
No, go ahead.
I don't know what the longest time period we've held the production tax credit. My understanding is we will not be holding these PTCs or production tax credit, Mr. Lee, for very long. That deferred tax asset Ms. Johnson testifies to in her testimony is quite low.
Okay. And do you have any familiarity with the PTCs that SPS's ratepayers earned through Hale and Sagamore that started to accrue in 2019 and 2020, but that weren't originally available for a transfer market? And I believe that became available with the Inflation Reduction Act in 2022. And do you have familiarity with that process and those particular PTCs?
I don't, other than what's in the stipulation authorizing us to recover transfer costs capped at 10% of the nominal value for PTCs from Hale and Sagamore wind projects through the SPS FPP-CAC. But I don't have any.
Voice trailed off.
I'm sorry. I said
cost capped at 10% of the nominal value of PTCs
for PTCs from the Hale and Sagamore wind projects through SPS's FPP-CAC. And I was just reading from 1.8C in the stipulation, but I don't have familiarity with how any PTCs from 2020 are being treated.
Okay. Do you know whether the transfer costs referred to in the stipulation refer to transfer costs that have already been accrued by SPS, or whether they refer to transfer costs that SPS will accrue for transfers that are done in the future?
Because this is a future test year case, my assumption is these are forward-looking, and Ms. Johnson can better speak to how that works in base rates.
Okay. Okay, thank you. Let's see. I'm just passing through questions that are more appropriate by my understanding at this point from Ms. Johnson. Okay. Okay, maybe you have familiarity with this. Are you familiar with case number 2400270-UT?
Hearing examiner Getko, I am very notoriously bad with remembering what cases go with what docket numbers. If you could show me what the docket title was, that would help, or an application front page or something.
Yeah, let me get there. I'm sorry. Yeah. Well, I could just bring it up out of my folder. Let's see. So 2400270 was an application for approval of continued use of its fuel and purchased power cost adjustment clause using a monthly adjustment factor under NMPRC Rule 550 and for implementation of certain matters through the FPP-CAC. It was a stipulation that ultimately resolve that matter. Does that ring any bells?
I am aware of 24-0027. I will just caveat that, but if I need to answer questions about a final order or anything like that, it would be better if I could see it.
Well, yeah, we might need to go there, but I don't think my question is too difficult. We'll see. I mean, we'll go there when we need to. But part of that case, and the final order at page 33 to 34, or maybe it's paragraph, says that SPS will file SPS's annual report on the sale of PTCs associated with the SPS self-build solar projects shall provide for the preceding calendar year SPS's monthly accounting for generated PTC value, PTCs transferred, and associated transfer costs. It hasn't been a year since that final order in that case. Is that report going to be filed in Docket 2400270? Do you know where SPS anticipates filing that report?
It will either be in that docket or in an annual report that we file. Hearing Examiner Gecko, I don't know exactly which one, where it will reside. And I don't, without having that case in front of me, I don't know where we agreed for it to reside, if we agreed it would be anywhere.
Yeah, I couldn't locate that it agreed to reside anywhere. So
certainly if the commission prefers that we file it in that docket, we can do it. We can file that report in the docket.
Boy, I guess I'm not, I don't want to speak for the commission, but I might be able to figure that out by talking to myself or my co-hearing examiner with some time. We could always include that later. I appreciate that. Would the information that goes into that report be something that you could provide on kind of a short time frame here in a bench request if we wanted to see that information for what's occurred over the last year?
I am not the one that is in control over that information, so I don't want to speak to how long it would take to put it together. Certainly, I can go back, Ms. Hardy can go back and talk to folks about what a reasonable time period it would take to get that information together for you. But I don't know.
Okay, I'm gonna when we go on break, I'm gonna discuss with my co-hearing examiner, and I may see if there's a bench request issue on that could be helpful.
Okay.
But I think, okay, thank you. Okay, this may be one for somebody else, but I'm not sure. The stipulation 1.11 on page 9.
.11 on page 9.
Did I make a bad note? Let's see here.
Oh, yep. Okay. Sorry. Okay. Yes, sir.
The second paragraph there states PTCs will be allocated on an energy basis. Do you know what that means?
That rather than allocating them on a capacity basis, they'll be allocated on their energy basis to customers.
Thank you for that. Yep, I understand that because in the original application, it was done on a capacity basis. But specifically, what does it mean on an energy basis? And, my head went to, there's different possibilities. There's energy allocators that exist out there. There's structures of energy charges for companies. There's kilowatt hours that are charged to customers. Different rate classes have different rates per kilowatt hour. And so just I don't understand, I don't see detail there for what it means that PTCs will be allocated on an energy basis. And I'm wondering if there's an understanding of that amongst the signatories, including SPS.
Mr. Trowbridge testifies in this case on the provision, section 1.11. And he can provide information regarding the provisions in that section of the stipulation.
Okay, great. Just highlighting some things so I know to carry it over to Mr. Trowbridge. Okay. Moving on to another topic then. Kind of another topic, but not totally. So transfer costs. Transfer costs apply to both production tax credits and investment tax credits. And that's why I saw it as another topic. In your direct testimony, you testify to this on page 84, that SPS proposes to recover through the FPP-CAC any transfer costs it incurs to monetize the Hale and Sagamore wind project PTCs, capped at 10% of each PTC's nominal value. And then that's adopted in the stipulation at 1.8C.
That's correct, Your Honor.
So when I saw it, what I didn't find in the application or anywhere was, the reason for why 10%. And is there a rationale behind why it is reasonable that the cap is set at 10%?
So in general, for the Hale and Sagamore Wind Project PTCs, that provision is pursuant with the approved settlement in case number 24-00270 UT. But I recognize that the 10% cap is also stipulated to as well for the transfer costs associated with the ITCs for Cunningham BESS and Plan X BESS as well. That is a customer protection provision, recognizing that there's a timing difference from when customers receive the benefit of the amortized ITCs, and that and when SPS receives that cash value of the transfer costs, but it protects customers by capping that so that anything that goes above 10% of the nominal value of the ITCs, any of those costs, SPS wears that risk. Customers will not be responsible for those.
And so I did a Google, and what I saw online was that, the general knowledge that's out there is that transfer costs amount to be somewhere between 4% and 10%. And of course, markets change, but that's the general knowledge that I was able to pick up out there in the world. And so if the high end of the general market that's out there in the world, according to that information that I've been able to glean, is 10%. Is there motivation for SPS? I don't even know if there's mechanisms by which SPS can control what those transfer costs are. But if the protection measure is set at the high end of the range of what can be the charges, my question is, what motivates SPS to minimize those transfer costs? And an answer could be, you don't understand here in Examiner Getco. We don't have any control. But can you speak about this and what my concern is there?
Yeah, certainly, Ms. Coke can testify more to the control that we have over what those transfer costs are than I can.
Okay. Do you know if there are any agreements or stipulations or orders that establish any transfer costs on which SPS has the right to earn a return?
I don't know Hearing Examiner Getco, but we can certainly look and provide that information to you rather than have me try and remember on the stand off the top of my head.
Okay, that sounds good. Yeah, if you're able to do that, that'd be great. And
Okay.
even if it comes in through Miss Johnson or something of that sort,
Okay.
a little bit.
Let's just consider that formally a bench request, Ms. Lees and Ms. Hardy. So we just have that on the record there.
Okay. Next topic. And this one's a learning exercise. We'll see where we get to fill a gap in something I can't figure out and I don't understand. So with the ITCs, in your direct testimony at page 79, line 8 through 80, line 14.
I'm sorry, can you tell me what those page numbers and line numbers are again?
Yeah, page 79, line 8 is where you start to testify on the matter, and you go through to what I wrote down is page 80, line 14.
Okay.
And so what you discussed there is the Cunningham Best investment tax credits, the ITCs. And so you say, as part of that, when the ITC is generated, SPS will monetize its full value, either by using it or transferring it. And so, you receive the investment tax credit when the project goes live, is my understanding, more or less, correct?
Correct.
And so the full amount of that ITC goes to SPS at that time. And there's other places where, that's referred to as SPS is, cash benefit of the ITC. They get it in, SPS gets it in hand as cash. So then, you state there, customers will receive that value over time through 5-year amortization, through the 5-year amortization. And you say, because that unamortized balance of the monetized ITC reduces SPS's rate base as a regulatory liability, SPS proposes to apply a return on the unamortized amount at its 8.21% WACC to remain financially neutral while customers receive the full ITC benefit. So here's my confusion. When it's a PTC, ratepayers receive that credit in rates immediately, correct? Whether SPS has transferred that PTC or applied it to a tax, it is reflected in ratepayers' rates immediately, a PTC, correct?
As the under the provisions of the settlement, as the PTC is generated, it flows through the FPPCAC and customers realize that benefit.
And so it makes sense. Like, that benefit's been given to the ratepayers. SPS might not have been able to cash that out yet. And so SPS gets a return on the amount that they've forwarded to ratepayers through the FPPCAC, but that they haven't cashed out yet. With the ITC, it feels to me like it operates in reverse. SPS cashes the ITC and puts it in its bank account. But then it's a 5-year period where SPS amortizes that amount as an amortization expense to reduce rates in each of those 5 years. So in this case, with an ITC, SPS has the cash in its pocket. The ratepayers don't. But what I understand reading this testimony, by my understanding of it, is that SPS proposes to apply a return on the unamortized amount. Is that 8.21% return a positive to SPS's bank account? Or since it's a regulatory liability, is that a dollar amount that is credited to ratepayers because it's a regulatory liability instead of a regulatory asset?
That's correct. Any return on the regulatory liability goes to ratepayers, and that's so that we can amortize the full amount of the ITC over 5 years to mitigate any rate impact from just, immediately passing it on to ratepayers, and then the next year they don't see that benefit, right? So we are elongating the amortization for ratepayers so that it reduces their rate base over 5 years. And then in order to remain financially neutral while customers are receiving that ITC benefit, we apply that return. We apply the return.
Okay. Great. Because there's some language elsewhere, and we don't need to go there, where it felt like it was going the other direction to me, and I just wanted to clarify.
And certainly Ms. Johnson can describe how this works functionally in rates.
Where is that provision in the stipulation? Do you recall off the top of your head? I just want to look real quick at the language there. I'm going through the stipulation right now. There it is.
1.8b discusses.
Okay, so yeah, so we're on page 8 of the stipulation, B, subsection D. It says SPS may apply a return at the stipulated WACC to the unamortized balance of the ITC value and transfer costs. That WACC amount would be a benefit to ratepayers. It'd be a money that goes to the ratepayers. And so would you support changing that from SPS may to SPS shall? Because I don't think it would be a choice as to whether to provide that to ratepayers or not.
Sorry, I'm reading the provision that you're reading.
Thanks.
I view this provision as just authorizing SPS to apply the stipulated WACC to the unamortized balance of the ITC value and transfer costs, treating both the same.
And so just to understand that, the amount that's applied to the transfer costs, that's for money that's SPS is paid to do the transfer before they recovered it. So SPS would receive that WACC on transfer costs that are a regulatory asset, whereas the WACC applied to the unamortized balance is a regulatory liability, and therefore it increases the funds that go to ratepayers. Do I understand that provision correctly?
Yes, Hearing Examiner Getco, we're matching the benefits with the costs here.
Okay, great. Thank you. Okay, next topic. This regards deficiency payments for the Southwest Power Pool, SPP. And I'm in your rebuttal testimony in support of the STIP at page 56, lines 3 through 14. And there's a provision in the stipulation where SPS has agreed to withdraw its request to recover Southwest Power Pool deficiency payments through the FPP CAC, and SPS will use its best efforts to address short-term capacity needs through market purchases. And then the point that's in contention between SPS and staff is that, what's stated here is that SPS will defer as a regulatory asset, any such capacity purchases or Southwest Power Pool deficiency payments incurred through the effective date of new rates in SPS's next base rate case. And then it's subject to a $10 million annual New Mexico cap. So that creates the context for my question. Then I want to turn to, I'm sorry, I didn't mark this page. I'm going to read this, and I think it's, let me just, I think it's your answer, but staff witness Molden acknowledges that SPS withdrew its request to recover SPP deficiency payments through the FPP CAC, but he argues that the stipulation expands the scope of costs that SPS may seek to recover in a future proceeding by allowing SPS to defer short-term capacity purchases and Southwest Power Pool deficiency payments for future review. He views that provision as a net negative for customers. So, finalizing the context, the way I understand that, and to make this a question, do you understand it in this way, that the concern expressed by staff is that because there's a regulatory asset for either of those deficiency payments for the short-term market purchases, then there can be an accrual of carrying costs on the market purchases or those deficiency payments. And so ratepayers will end up paying more than what the face value of those market purchases or deficiency payments are. Is that a fair understanding of the way you've understood that concern from Mr. Molden?
My understanding was just that he opposed this provision because, as I say in my testimony, it expands the scope of costs that we may seek recovery of in the future. I would have to go back to Mr. Molden's testimony to reread it to understand if that was his concern as articulated in the testimony specifically.
So said, and this will give me my question, said differently, if those costs go into a regulatory asset and SPS is able to earn a return on it, it would result in ratepayers ultimately paying more than just the straight market cost or the straight deficiency payment due to the accrual of a carrying cost on that amount. Is that fair?
I think it would depend on the decision the commission makes at the time it reviews those costs and determines what's just and reasonable for ratepayers to pay. I can't guess what they will decide, but that would be a decision in a future proceeding.
So my question is this, and it's a solution-seeking question. Like, is there any method by which these capacity payments could be reviewed for reasonableness and included in FPP-CAC for recovery on a shorter-term basis to eliminate this concern that's been raised about a delay and what that, what might follow from that?
Hearing examiner Gecko, perhaps, perhaps SPS could explore what other regulatory processes are available to it, either standalone cases or existing cases that it could address this in. However, the stipulation the stipulation does contemplate that it's not just a future base rate case, but it could be a future proceeding. So I think that if those options are available to bring forward a request earlier, that the stipulation is allows for that.
Okay. Yeah, because these kinds of market purchases, correct me if I'm wrong, aren't, if it was fuel, it would go through a fuel clause filing and go through a review process on a fairly regular basis. Is that correct?
Yes, fuel goes through the fuel and purchase power agreement clause, and that's reviewed pursuant to the rule. Yes.
Okay. All right.
So I guess in short, I think that the stipulation, the language in the stipulation allows for SPS to kind of do that analysis of when the best timing of a future proceeding to bring this forward would be.
Do you have any immediate thoughts on, if it weren't in your next rate case, what a more immediate proceeding would be to provide a timely review of
Yeah.
that?
I think you're thinking about FPPCAC, which is where my mind goes as well.
Okay. And have you already had thoughts of like how that process would be finalized if you were to choose to go that route?
Not at this time, hearing examiner Getco. I think
Okay.
we need to see whether the stipulation is approved.
First things first.
Yeah.
All right. Okay. And let me just to give a little preview. Getting close. You know, I use this. Yeah. Not everything that I cover is big dollars, but I want to talk a little bit about donations and contributions. And in your direct testimony at page 50, lines 13 through 14, you support, you know, SPS is seeking a recovery for certain donations and contributions to community and economic development organizations in SPS's service area. So
I apologize, hearing examiner. What page were you looking
your
at?
statement, your general statement is on page 50 of your direct testimony, starting at line 13. And okay. So donations and contributions are covered by Rule 17.3.350.10 NMAC. And provision A of section A of that rule says that contributions or donations to any political candidate, any political party, any religious cause, or any social, recreational, or fraternal organization shall not be allowed as a cost of service. So I reviewed the community organizations that, and you know, are listed, and I have a question about a couple. One of them is GIS Planning Incorporated.
And I'm sorry, Mr. Hearing Examiner, are you looking at a specific page of my testimony or
Yeah,
attachment?
let me get to that exhibit. I could tell you the name of the exhibit. It might take me a minute. I think it's 9 if I go to my brain. ZL6. So this is on PDF page 142 of your direct testimony is where it starts. It's a 12-page attachment. And on page 3 of that attachment, it starts to list the organizations to which SPS has provided community service contributions and donations.
Yes. I just need to zoom in on this attachment. It's
yeah.
Yes, sir. Okay.
So I took a look at a few, and of course my eyes got drawn by bigger dollars and such. And for people that are looking at this for the first time, there's a difference between the dollar amount and the total amount, and then the total requested New Mexico amount. I think it's worth noting that. But GIS Planning Incorporated stuck out to me, and when I researched it, everything on the internet says that it was purchased by what appears to me to be a company in 2017. And I'm wondering if you have familiarity with that, or who might.
I don't have familiarity with an alleged purchase of GIS Planning Inc.
And so, do you delegate the responsibility for developing this attachment and approving of the communities, the organizations that receive these donations and contributions?
The attachment is created under my direction. I don't delegate I don't make the decision on every community contribution or donation that's made.
Okay.
I just don't have any knowledge of this particular organization being purchased. I don't know one way or the other.
Okay. So I want to go to line 17.
Line 17. Okay.
The Fellowship of Christian Athletes. How do I understand that to fit with the prohibition under 17.3.350.10 that states that contributions or donations to any political candidate, political party, religious cause, or any social, recreational, or fraternal organization shall not be allowed as a cost of service?
In looking at the purpose of the organization, it appears that it's an organization that empowers coaches and athletes. And I'm not aware of any party who has challenged this. Certainly, it is the commission's. It is under the commission's purview to address these and decide whether they're appropriate for recovery under the rule.
Okay, thank you. Yeah, because staff did challenge the entirety of the donations and contributions as being not adequately supported within the application. Are you familiar with that?
Yeah, I would have to go back to the testimony challenging it. I will say that donations and community service contributions have not been contemplated in this stipulation.
In not being contemplated in the stipulation, what does that mean?
There's no provision that addresses it in the stipulation. So not a stipulated to provision in this.
And so if it's not stipulated to, does that mean that what you applied for in your application is what governs? That's what I mean. When it's not covered in the stipulation, what's my default for understanding what occurs with something that was included in your application but is not covered in the stipulation?
Yes, hearing examiner Gedko. So the provisions of the stipulation inform adjustments made to the cost of service, and Ms. Johnson also addresses that in her testimony and provides a table to show how the cost of service is adjusted pursuant to the stipulation. So that should give you that tie out.
Yeah, when I review that table in Ms. Johnson's testimony, it doesn't list anything with respect to donations and contributions. And then we have the couple $1 million bucket catch-all that was referred to during the questioning with Chairman O'Connell this morning. Can you tell me how that piece relates? So we have a, you know, this is just, you know, understanding how to handle something. And, you know, if the commission decided it wanted to address anything in this section, but, you know, a request for $112,541 for community and economic development, contributions to community and economic development organizations that would be included in rate base. And there's nothing out of the ordinary in the general idea of this. It's even in rule. It's in the application as being requested as cost of service. It's not in the line items of that table that you referred to in Johnson. There's a catch-all bucket. Should I assume that it would be taken out of that catch-all bucket if the commission decided, if I wanted to provide a recommendation to the commission to include or not include that amount? How should they consider where that's located in respect to the stipulation that's been filed?
So that $2 million of unspecified decrease to our to the revenue increase is we just need to manage our own O&M and capital spend costs to manage that $2 million. Certainly, contributions and donations falls under the O&M that we will need to manage in order to meet that $2 million decrease. But it's not specified in the stipulation, so there's no finding one way or another in the stipulation.
Okay. All right. Thank you. Thank you. Just a more general question, and you know, I try to listen to some other cases, and you know, I listened to the open meeting, and you know, in an open meeting a while ago, I heard about the, you know, the environmental commitments that SPS makes, you know, with respect to 2050 being 100% renewable or zero carbon, and you know, that was addressed with respect to the 2045 limits and of the state of New Mexico, and then I review the donations and contributions, and I don't see anything with respect to an environmental organization. And I'm wondering kind of how often you all update your organizations to which you donate and contribute, and what kind of process that goes through, and whether you work to align those with the stated goals of the company on a regular basis. Could you speak to that?
So on an Excel energy-wide basis, I don't know how that process works. But these contributions and donations that are made that are identified in my attachment, my understanding is that they're more localized in nature and more localized to the communities in which we serve, and are responsive to requests from those community organizations for participation and, you know, donations for them to be able to provide services and have a presence in our communities.
Okay, thank you. That's helpful for me and my understanding and awareness. Thank you. We won't be on this topic much longer, but I have another couple questions. What I struggle with a little bit, and maybe you can help me, is I hear so much about these days about, the difficulty of making ends meet, et cetera, et cetera. It's in the news all the time. And I also understand that different people have different prerogatives in the world. And how can I feel more comfortable with what I see as this essentially dollars coming in through rates that a ratepayer doesn't have a choice to pay or not if they want to keep their lights on? And then the decisions as to where that certain amounts of that money goes is made by other people. And this happens in the world. We elect folks to office and they make decisions. We don't always agree with them and such. So maybe it's as simple as that. But I found in reviewing and trying to prepare myself for this case, like, I just don't feel really comfortable with that. I imagine some student that's barely getting by to go through college and cares about certain causes, and I just wonder, does that ever bother you? Is there a way that can help me think about it? Should I understand that there's good processes? I don't know. It's just on the floor, and we have an opportunity to talk, and I'm not going to ask questions to you forever. I'm getting close to the end, but this is one that was on my mind.
Yeah. Well, as it pertains to donations, if that's what you're talking about specifically, I think you should think about it in terms of the process and the process that allows recovery of these costs under 17.3.350.10 NMAC. I think you identified that. That kind of governs how these costs can be recovered. But in general, when you're thinking about that and you think about this case, I would look to the fact that this is a stipulated agreement. It has been negotiated among many parties with diverse interests. We have the New Mexico DOJ in this stipulation. We have Prosperity Works in this as a signatory to the stipulation, who and other parties that are interested in many different diverse interests. And it is a product of heavy negotiation among those sophisticated parties. And as you can see from the settlement, it brings the revenue increase to customers down significantly. And so I think when you're thinking about that and you think about the process that stands in place of competition, I think about that as that process as what is setting just and reasonable rates and how you can ensure that the ratepayer is paying just and reasonable rates. So we're taking part in that process right now, obviously. But the negotiated process is favored under New Mexico law because the Supreme Court and the Commission have found that if all the factors in that evaluation, the three factors in the evaluation, are met, that usually that resolves the issues in the case and result in fair, just, and reasonable rates. So when thinking about, whether certain costs should be passed on to ratepayers or not, I think we're in the process right now. And certainly the signatories to this agreement negotiated very rigorously on this stipulation. And there were puts and takes, but it results in rates that the signatories all agree are fair, just, and reasonable. And And that is kind of the process in which we are setting rates, and we've always set rates for customers to make sure that that happens.
I appreciate that. I appreciate putting that framework on the questions that I had in particular to the donations and contributions. So thank you.
Yeah. I think that's also why you evaluate the stipulation as a whole, right? Instead of, you look at the stipulation as a whole. Is it fair, just, and reasonable? Does it meet all of those factors? And it resolves the issues in the case, if certified and then approved.
And if something in the stipulation violates the law, then what do I do when you tell me to review it as a stipulation as a whole?
Well, first of all, I don't know that there's anything in the stipulation that violates the law, but the commission needs to follow the law, as do the parties when they're working on this. So parties need to be putting forward, the stipulation, and I don't think SPS would agree to a stipulation that violated the Public Utility Act or any regulatory principle, and this stipulation does not do that.
Okay, thank you. All right, just a few more topics with a small number of questions. Can we go to your direct?
Okay,
testimony
I'll just say
and-
we're at about 70 minutes since our lunch break, 75 minutes since our lunch break. So why don't we take a 10-minute break here for everybody, Mr. Lees, and get some fresh air and stretch the legs, and we'll be back here. We'll recess for 10 minutes and we'll be back here at 2:25. Thank you. Hey, everybody, good afternoon. It's 2:25, back in recess from our first afternoon break. Mr. Lees, how do you feel? You ready to proceed?
Yes, sir.
Okay, great. I think hearing examiner Gecko should be here momentarily, as hopefully will Ms. Hardy and the other parties. Okay, I think we're all set. Back from our recess.
Hi, everybody. I'm just centering myself on the last couple of topics here and making sure I return to where we were. So I only have one small topic I'd like to talk about, Ms. Lees, which is the provisions in the stipulation for large load tariffs. And my question is with respect to the timing. If a final order is issued in this case and something should be filed within 6 months, could, the statutory deadline is mid-December, obviously aiming for something earlier than that. In a recent case, there was testimony given by SPS witnesses with respect to filing that this summer. And that was provided as an explanation for concerns that were raised with respect to rate impacts in different classes. And so, could you speak to why that timeline changed?
Well, we're still in the summer, I will say, and through the negotiated process, I think the parties were comfortable with within 6 months recognizing that they did want us to do more intervener outreach on it. So it's just represents the negotiated provision that we already are doing intervener outreach. We've met with most of the parties already in this case on it, but that we will gather more input on that before filing it.
And there was some concern in certain direct testimony regarding, there was a suggestion at one point of perhaps like tracking costs that a large load customers might be responsible for. Do you believe there's a large amount of costs on the system right now at this time that are being incurred specifically for certain large load customers that other customers are paying at this time?
Well, certainly we have large industrial service customers on the system. You see those rates set in this case. But there are a variety of factors that are going into the revenue increase in this rate case. For example, we have the grid modernization costs that are currently being recovered in a rider rolling into base rates as part of this proceeding. So I don't think there's like any one cause, and certainly it's not just a large industrial customer or one large customer that's causing this, causing SPS to need to file a rate increase at this time. It's a number of investments we've made, a number of cost of service changes we need to update.
Okay. And then my last question would be, is with that commitment to file that.
I'm sorry, hearing examiner Gatco, could you get closer to the microphone?
Yeah. With the commitment in the stipulation to file that rate within 6 months after a final order, is there some kind of process there that would interact with the base rates that would be set in this case? Or can you help me understand what the filing of that would do and how that would interact with the rates that are being set in this case?
Well, how I'm thinking about it today, and I will say we haven't filed that case yet, so I guess that thinking could change. But there's no large customer specific large load tariff in place today. So we would have to establish a tariff. I envision that tariff would include certain provisions under which those specific customers could take service from SPS. If you look at large load tariffs around the country today, there's anything from minimums to exit fees to their term. There's many different provisions in those tariffs. So that would set the tariff. We'd get that tariff approved, and then I believe we would set whatever the rate is for that new tariff in a following rate case.
Okay. All right. Thank you. Thank you. So that so the implementation of that tariff would occur upon a final order in the next rate case, of course, if that were the path that were followed. Just to kind of restate what you said.
The rate would be set for that tariff. Once the tariff is approved, any customers that meet the provisions or requirements, parameters in the tariff, my assumption is it will define what a large load is in that tariff. Would the tariff provisions would be applicable to those customers coming onto the system? Again, this is like I am theoretically talking about how I could see it work. We have not made a filing yet. And we are still collecting input from interveners and other interested stakeholders.
Yeah, I only ask it because, like, if we don't have a rate, even if we have a tariff, like, how do you charge somebody that tariff? Even if they meet the parameters that are defined. So when we see it in the stipulation, it's at 6 months. Like, okay, oh, you see that, you say, whoa, it's coming right around the corner. Well, we're talking about filing a base rate case in a couple of years, SPS is, or maybe sooner. But rates going into effect from that, not 6 months after this final order in this case. So as far as the applicability of that tariff to any particular customers, it's really pragmatically going to go into effect when a rate can be set for that tariff. Right? Or am I missing something totally there?
Well, loads that large will likely enter an energy service agreement with the company, and that agreement will have provisions that dictate what the service looks like ahead of a rate being set in a rate case. Again, this is a little bit theoretical, hypothetical, because we're not there yet.
Okay, thank you. That's all the questions I have. I appreciate you answering my questions today. Thank you.
Thank you, Hearing Examiner Greco.
Excellent. Thank you, hearing examiner Gecko. So I'll just turn to Ms. Hardy and ask if she has any follow-up questions after hearing examiner Gecko's inquiries.
I do not. Thank you.
Thank you, Ms. Hardy. Ms. Lees, on behalf of the commission, thank you for your time, for all your professionalism, and I believe you may be excused.
Thank you very much.
Thank you, Ms. Lees. Okay, Ms. Hardy, are you ready to call your next witness?
I am. SPS's next witness is Michelle Keatsman, and I think she may just need a minute to switch out with Miss Lees into the witness room.
Sure, no rush. Thank you.
Thank you.
And while we're waiting, may I ask staff counsel who will be cross-examining Ms. Keatsman?
Yes, hearing examiner Schaefer, I will be cross-examining Ms. Keatsman.
Great, thank you. Also, just for your situational awareness, Ms. Amer, I think your background has prevailed, and I cannot see you. I don't think we can see you. There you go. Okay, great, thanks. And Ms. Amer, also while we're waiting, do you still anticipate 5 minutes of cross-exam time for Ms. Keatsman?
I would like to use an additional 5 minutes from our remaining from Miss Lees. So to make that.
Excellent, okay. 5 minutes, you said?
Yeah, if you would allow that.
Sure, that's fine. I just took a note, and we should be ready once Ms. Keatsman comes online here and we do our direct and our swearing in. Okay, excellent. Looks like Ms. Hardy that Ms. Keatsman is online. Thank you. You're on mute, Ms. Hardy, but Ms. Keatsman, thank you for being here with us today. We're going to go ahead and get you sworn in by our court reporter, Mr. Lee, who will speak to you as soon as he's ready.
Ms. Keitzman, would you please raise your right hand? You solemnly swear the testimony you're about to give the matter not pending shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Go ahead.
Thank you. Go ahead, Ms. Hardy.
Ms. Keatsman, can you please state your full name for the record?
Michelle A. Keatsman.
And by whom are you employed and in what capacity?
I'm the Senior Manager of Capital Asset Accounting, employed by Xcel Energy Services.
Ms. Keatsman, did you submit SPS exhibits 13 and 14 in this case, and 15 as well?
Yes, I did.
Thank you. And since those have already been admitted into evidence, I have no further questions, and Ms. Keatsman is available for cross-examination. Thank you.
Thank you, Ms. Hardy. Ms. Amer, are you prepared to proceed?
Yes, thank you.
Go ahead.
Good afternoon, Ms. Keatsman. My name is Judy Amer, and I am representing the legal division and the utility division at the New Mexico Public Regulation Commission. I would like, yes, hello. I would like to direct you to Staff Exhibit 5, which is the direct testimony of Jonah Malden on page 69, and I'm going to read it so that you don't have to hunt for it. It says, in my experience reviewing cost of service studies, a well-constructed filing allows staff to follow the path from a witness's testimony to the supporting work papers, and from work papers into the functioning cost of service model with relative ease. In this proceeding, that path was frequently unclear. Work papers were not linked to the cost of service model, and certain adjustments reflected in testimony could not be traced to supporting calculations without significant effort. In some instances, numbers appearing in work papers were hard-coded with no underlying formulas to explain how they were derived. As noted in Commission Rule 17.1.311 and MAC, the fully functional electronic format requirement exists precisely so that staff and interveners can make adjustments that carry through to the jurisdictional revenue requirement. The challenges encountered in this case made that process far more difficult than it should have been. The practical consequences of these challenges is that staff spent disproportionate amount of time and effort deciphering the mechanics of SPS's work papers and models, rather than focusing exclusively on the merits of each proposed adjustment to the revenue requirement. With that testimony in mind, is SPS willing to correct that deficiency in its next rate case?
Objection.
Go ahead, Ms. Hardy.
Well, Ms. Amer just read a long passage of staff's testimony that Ms. Keatsman, I don't believe has had an opportunity to review as she's sitting there. And I also think this is outside the scope of Ms. Keatsman's testimony.
Mr. Hearing Examiner, this is not outside the scope of her direct testimony because she was using cost of service models and work papers regarding 440 filings, and that's all within her testimony. And it is a fact of this case that she's known about since staff filed its direct testimony on May 1st.
Okay, let me just ask a question here, Ms. Amer. So your question was, with that testimony in mind, meaning staff's testimony, is that correct?
Yes.
So with staff's testimony in mind, is SPS willing to correct that deficiency in its next rate case?
Those deficiencies.
Okay, those deficiencies. I'm just reading from the real-time transcript here. So you're asking Ms. Keatsman if she can comment on a staff witness's conclusion that there are deficiencies. Is that correct?
Yes, I'm asking her, she could, for instance, say there are no deficiencies to correct. Or she could.
Okay, well, I would sustain the objection and maybe allow you to ask the question in that way without predicating it upon a conclusion that is offered by staff in its testimony. Maybe you just want to ask Ms. Keatsman, are there deficiencies in the process?
Yes, Mr. Hearing Examiner. Ms. Keatsman, do you agree that with staff that there are deficiencies in the process in this particular application?
No, I do not.
Okay. Next, I would like to direct you to the direct testimony of Mr. Darren Zigich. Exhibit 1, page 9, line 16, and I'm not going to read it. I'll allow you to read it.
Ms. Amer, could you share your screen or?
I don't have it open. I have it on a, I can try to open it, but
I'll just say, let me just say something here for all the parties. We can make best use of our time just asking substantive questions about certain elements of parties' testimony or witness testimony. I think sometimes when we try to search and cite and read verbatim the testimony, it becomes a bit complicated and slows us down. So maybe Ms. Amer, you're aware of Mr. Zigich's conclusion, and maybe you could paraphrase that and ask Ms. Keatsman about that, for example. It's just a suggestion, but that's an observation I would like to share with everybody.
Yes, I understand. Ms. Keitzman, do you believe it's important for staff, the commission, and other stakeholders to have full transparency into capital projects and costs being requested in a rate case and the associated pre-project Rule 440 report filings?
I agree that staff should have appropriate support for all the capital investments requested in the case.
And do you agree that without that transparency, there's no way for staff to assess whether the projects were completed as planned and within the estimated budgets or the reasons for overruns?
Objection. Examiner Schaefer, you're muted.
Thank you for that. Ms. Hardy, what's the basis for your objection?
It's that Ms. Amer is asking Ms. Keatsman to comment on whether staff has any way to review information, and that seems like something that's not within Ms. Keatsman's scope.
Mr. Hearing
Ms.
Examiner.
Amer, do you have a response, Ms. Amer?
Yes, on page 6 of Ms. Keatsman's supplemental testimony, she testifies a lot about 440 notices and what they contain and why the ones that SPS has provided were sufficient.
Okay, I think it's a pretty straightforward question. I'm going to overrule the objection, and I'll restate the question for you, Ms. Keatsman, and answer to the extent that you know. Do you agree that without that transparency, there is no way for staff to assess whether the projects were completed as planned and within the estimated budgets or the reasons for overruns?
I believe that the transparency that as far as like the support behind the capital projects would be necessary as far as tying them directly out to Rule 440 filings. I don't know.
Is that the end of your response? Because I have another question.
Yes.
Thank you. Can SPS in its next rate case create a simple way to link 440 filings directly to their projects listed in their rate cases?
I believe we would be open to working with staff and parties to determine the best way to provide that information going forward.
Thank you. Can SPS roll all the WBS level 2 costs into the WBS level 1 line item to easily compare it to a previously submitted 440 report?
Are you referring to within a specific subset of data, or can you explain?
Yes, I'm discussing your response in your supplemental testimony on page 6. Do you have that in front of you?
Yes, I will pull that up.
By the way, Ms. Amer, you have 1 minute left.
I already asked my question.
Okay, you said page 6?
Yes. And it starts with the by contrast.
Which line?
I think on line 14, it says, by contrast, the Rule 440 notices report information at WBS level 1, which corresponds to the overall project. And then
Ye-
it goes on. Yeah. So my
Yep.
question, and you can, the court reporter can read over my question.
Are you
I'll
referring, go ahead, Jed.
I'll read it back, Mr. Lee. Yes, I believe your question, Ms. Amer, was, can SPS roll all the WBS level 2 cost into the WBS level 1 line item to ease load compare if to a previously submitted 440 report?
Excuse me, what I said, to easily compare it to the previously submitted 440 report.
Thank you. Thank you. We're working off just a draft real-time transcript here. So yes, Ms. Keatsman, answer if you know.
Yeah. So the attachment is derived off of my attachments in my direct testimony, which are level 2 projects that are placed in service in the base period, linkage period, and future test year. So if there were level 2 projects that were placed in service outside of that period, you would not be able to add them up to equal the total WBS level 1 project that would be in the Rule 440 filing.
But
Miss Amer, your overtime. I gave you an extra couple minutes, so thank you so much. There's never enough time, is there?
Yeah.
Miss Hardy, do you have any? I don't believe any other party has reserved time to cross-examine Miss Keatsman. Is that correct? Okay, that is correct. So, Miss Hardy, I turn the witness to you if you have any redirect for Miss Keatsman.
I do not. Thank you.
Thank you, Miss Hardy. Hearing examiner Getco, do you have any questions for Miss Keatsman?
I do. I have just a couple. Good afternoon, Ms. Keatsman.
Hello.
In your testimony in support of the stipulation, and this is on page 4, you answer the question. The question is, what does it mean that the agreed upon depreciation rates have a net $0 impact on the stipulated revenue deficiency? And you answer that the depreciation rates that are included in Exhibit C, when they're applied to the test year, they result in no change to depreciation expense compared to depreciation expense in the test year using previously approved rates. So it ultimately results in no change to the revenue deficiency. And since I'm not an expert on this, I see in your testimony, the extension of the lives of 7 or 8 different plant. How does it not result in a difference in revenue? Is that an active process to set depreciation rates at a level that coincides with the extension of time for those plants, and so that you work numbers to make sure that you don't affect the revenue deficiency? Like what's going on there at a little level that I don't understand?
Yeah, so the extensions, the life extensions that are noted are not the only changes in the depreciation rates. Those are a majority of what's impacting, but there's offsetting changes in lives and rates to bring that revenue deficiency or depreciation expense change to 0.
So there's changes to other resources that aren't listed in that Exhibit C that help you to accomplish that. Did I understand that correctly?
No, thanks for that clarification. So Exhibit C has all of the depreciation rates. So that is inclusive of all the changes. I was referring to the question right above the question you referenced where it listed the life extensions, which is a subset of the rates included in Exhibit C, but not all of them.
Got it. So the ones that are listed just above there in the question, the effects that we have that in depreciation due to those changes that are listed there, they're offset by changes to other resources that are in Table C.
Correct.
Correct. Okay. So it doesn't change the annual revenue deficiency. If we looked at over a 20-year term, does this have an effect on the overall amount of dollars that will be paid by ratepayers? And as context for that, me not being an expert in it, I think about how certain plants hit the end of their depreciation schedules. And I would imagine that a plant that, you know, hits the end of a depreciation schedule and then it's $0, you know, we have fewer years in which interest is applied to the rate base for that resource. And so to summarize, having given that context, my question is, even though what you've achieved is an annual stability in the revenue deficiency, are there effects that increase costs over 20 years to ratepayers due to these depreciation changes?
So the revenue deficiency is 0, so that's what will be included in rates and the cost of service. And as far as the plant goes, you know, those rates will be applied to plant as time goes on. There will, if there are changes in plant, that may change the expense to the company, but not, you know, would not change what's collected from customers through rates, absent a rate case or other rate recovery mechanism.
Let me just ask you one real particular example, and it'll just help with my understanding. So you list there on page 4, for example, the extension of the service life of Jones Unit 1 from 2031 to 2045. And of course, there's going to be additional O&M over the life of that plant, and there might even be capital investments. But let's say that plant's just top notch, and you don't have to make it. You know, you don't have to do anything other than O&M. I know that's not a reality. Would the lifetime cost for that resource, exclusive of O&M, go up as a result of extending that depreciation time schedule?
No, like the cost of the plan is now allocated over a longer period of time, but the overall cost that we're allocating over that period of time does not change.
But there's more years to apply a return on the cost of that plant in rates, correct?
That is correct.
Okay. So, okay. So then I want to ask, you know, because what that says is, okay, you know, there's a trade-off there of we've extended this life, you know, and there's going to be additional, you know, whack applied to that over the term of the new depreciation schedule. What's the what's the core motivation? This is probably in your testimony. I'm sorry, I don't know. But what is the core motivation for the lengthening of these terms?
While I calculate the impacts of those, there are other witnesses that cover the plants themselves and why that was chosen as a resource or change in the life. So I can't speak to that specifically.
Okay. And then my last clarification then is would you point me to a particular witness for the rationale for the changing in the life of the plant?
Subject to check. I think it's Heffington. I believe it's Heffington. Someone might be able to correct me if I'm wrong.
And then the life of the plant can be different than the depreciation schedule of the plant. Like it can be fully depreciated prior to retirement of the plant, correct?
Not, I mean, it can, but that is generally not the case. And we, adjust depreciation as we plan, as those plans change in order for that not to occur, so that the customers that benefit from the plant are paying for that.
All right, thank you. I appreciate those explanations. Thank you. That's the extent of my questions.
Great, thank you, Hearing Examiner Gecko. Ms. Hardy, do you have any follow-up questions for the witness?
I do not. Thank you.
Okay, well, given that there's no other party requesting time to cross-examine and that the hearing examiners have asked their questions, Ms. Keatsman, I believe you may be excused.
Thank you.
Thank you so much. Okay, Ms. Hardy, who is your next witness?
Mr. Examiner, SPS's next witness is Allison Johnson, and Mr. Coe will be presenting her testimony, and we'll just need a moment for her to switch out to the witness room.
Of course, thank you.
Thank you.
While we're doing that, I'll just confirm, Ms. Amer, you will be the staff witness for Ms. Johnson, or staff counsel for Ms. Johnson?
Yes, that is correct.
Okay. And I have here 37 minutes. Is that still correct?
Yes.
Thank you.
And good afternoon, Your Honors. William Coe on behalf of SPS.
Good afternoon, Mr. Coe. Thank you for being here with us.
Yes, sir.
Mr. Coe, could you tell me what firm you're with?
Yes, sir. Balch and Bingham, the same firm as Mr. Pearsall.
Thank you.
Mr. Coe, is your witness ready?
I do not see her on the screen, Your Honor. She's in another room. If we can, and all we had to do was talk about her. She has appeared. Your Honor.
Okay, great. Thank you for being with us today, Ms. Johnson. We're going to go ahead and get you sworn in by our court reporter, who will begin that process as soon as he's had a moment to prepare.
Miss Allison, would you please raise your right hand? You solemnly swear the testimony you're about to give the matter not pending shall be the truth, the whole truth, nothing but the truth.
I do.
Thank you. Go ahead.
Thank
Good
you, Ms.
afternoon.
Johnson. Go ahead, Mr. Coe.
Good afternoon, Ms. Johnson. Will you please state your name and your business position for the record?
My name is Allison M. Johnson, and I am employed by Excel Energy Services as the Director of Revenue Analysis.
And Your Honor, Ms. Johnson's testimonies have all been entered into evidence. So we would tender Ms. Johnson for cross-examination.
Thank you, Mr. Coe. Ms. Amer, you have the witness.
Thank you. Good afternoon, Ms. Johnson. My name is Judy Amer, and I represent the New Mexico Public Regulation Commission Utility Division staff, and I'm a member of the legal division at the NMPRC. I would like to ask you about your rebuttal testimony. Did you prepare Schedule AMJ-STIP R1 to your rebuttal testimony in support of the stipulation?
Yes.
And does that schedule provide your breakdown of the revenue requirement reductions reflected in the settlement?
That's accurate. Yes, it does.
And does the stipulation itself include Schedule AMJ-STIP R1?
It does not.
Does the stipulation expressly incorporate Schedule AMJ-STIP R1 by reference?
It does not.
Does the stipulation specifically identify some of the adjustments in your schedule?
It does.
But not every line item on Schedule AMJ-STIP R1 is included in the stipulation.
That's correct. Not all of the terms that would support the calculations in AMJ-STIP R1 are expressly stated in the stipulation.
And not every line item on Schedule AMJ-STIP R1 appears as a defined adjustment in the stipulation itself. Is that correct?
That's correct.
Do the other parties agree with Schedule AMJ-STIP R1? The signatories that is what I meant to say. Do the other stipulating parties agree with Schedule AMJ-STIP R1?
Not the list in its entirety. As we pointed out, many of the terms that the signatories agreed to were provided or expressly stated in the stipulation. However, I think we've noted throughout my testimony and also that of Ms. Lee's that some of these calculations, as you can see here, were either identified previously and previous steps in the proceedings, such as the revisions filing or the notice of corrections. In addition, we did agree, the stipulation does agree to a revenue increase that involves that non-defined reduction amount. So in other words, the stipulation does agree to an increase that involves an adjustment that is not correlated to any one issue in particular. So I would respond that no, the signatories didn't agree to every item expressly within the stipulation, but mathematically to arrive at the revenue increase, there had to be additional reductions.
So would you agree that the numbers in your AMJ STIP R1 are just illustrations?
No, in fact, they are not illustrations. Many of them they are exact calculations to arrive at the adjustments to the cost of service based on the terms agreed to within the stipulation. In addition, that non-defined reduction, which was an additional reduction that had to be made in order to arrive at the stipulated revenue increase of the 90 million demonstrated in the table. So they are exact calculations.
Are they binding on the other parties to the stipulation? Another, you can answer that. I'll ask a follow-up question.
Can you maybe clarify what you mean by are they binding?
If, for instance, it was discovered by one of the signing parties that one of those exact numbers was incorrect, could they have the right to hold SPS to that particular number, since it wasn't part of the stipulation, as you said?
That I do not know.
Was this Schedule AMJ STIP R1 provided to staff before staff filed its testimony in opposition to the stipulation?
No, this table was filed in my rebuttal to staff's testimony in opposition of the stipulation, so it was provided after, in response to staff's testimony.
Why wasn't it provided prior?
In essence, a lot of the calculations that are demonstrated within the table could have been arrived at prior by staff or other intervening parties via some of the other schedules that were provided on behalf of SPS. For example, in response to the hearing examiner's third bench request, SPS provided updated schedules that were requested, which represent the cost of service at the stipulated revenue deficiency amount. So in essence, a lot of these adjustments could have been arrived at by comparing those schedules to our initial filed cost of service.
So this, am I right to interpret what you said as these figures could have been provided before staff filed its testimony in opposition?
Objection. Misstates Ms. Johnson's testimony.
Ms. Amer?
I'll rephrase the question. Were these figures calculated completely after staff filed its testimony in opposition?
No, in fact, some of them are expressly stated in my testimony in support of the stipulation, just not all of them were explicitly stated. The revenue requirement of all of these issues were not explicitly specified in my testimony in support of the stipulation, but many of them were. At the time that we reached the stipulated revenue increase, this table could have been provided and calculated, but only at that time, because many of the calculations on this table are the result of the terms agreed to in the stipulation, if that makes sense.
Were any of these figures calculated after staff filed its testimony in opposition?
No.
Thank you.
These were all calculated at the time the stipulation was reached.
But as you said, they were not filed with the stipulation.
No, that's correct. This table was not provided then.
Okay, turning to the comprehensive stipulation itself, section 1.1. Isn't it true that it expressly states that the stipulated base rate revenue increase, quote, is not associated with any specific calculation involving any stated cost of service component.
That's correct.
And doesn't the stipulation further state that the signatories arrived at the $90 million figure, quote, through a compromise of various issues raised in this case without specifically accepting or rejecting for purposes of this stipulation any rate-making issue or principle?
That's correct.
So given that language, isn't it true that the signatories did not strictly agree to the exact mathematical adjustments you laid out in table AMJ stip R1?
I would disagree with under the premise that the signatories agreed to the very terms to arrive at these adjustments within the stipulation. For example, if you agree to an amortization period of a certain number of years, you are expressly agreeing to that amount divided by that number of years. You could not arrive at these adjustments without the terms that were agreed to within the stipulation.
My question was a little different, and I'll repeat it. Isn't it true that the signatories did not strictly agree to the exact mathematical adjustments you laid out in table AMJ stip R1?
Yes, in the context of your question there, then they agreed to the $90 million revenue deficiency, but not to the explicit revenue requirement impact of each issue.
Okay, I want to move to your direct testimony, page bottom of page 4 through top of page 5.
Okay, give me
Where
just
you, I'll give you a moment.
a second to get there.
And I'm sorry, Your Honor, Ms. Amer, would you say again what page of her direct testimony you're going to?
Yes. Direct testimony, page 4 to 5.
Thank you.
Bottom of page 4, moving to page 5.
Okay, I'm there.
Great, thank you. I won't read it, but in that part of your direct testimony, isn't it true that you state that the 175,354,544.62 is necessary for SPS to recover its reasonable costs of providing service to SPS's New Mexico retail customers?
That's correct.
Okay. And then in your rebuttal, and now I'm losing the place where I had that. You say that the $90 million is necessary for SPS is reasonable and necessary as well. Is that correct?
That's correct.
So then my question is, do you think it is inconsistent to say that 175 million approximately is necessary for SPS to recover its reasonable and necessary costs, but in your testimony in support of the stipulation rebuttal to say the 90 million isn't reasonable and necessary?
I would say both represent reasonable and necessary revenue requirements to recover our costs. What we file in our initial filing represents all of our forecasted costs that we anticipate to incur throughout the future test year. So that is representative of all of those costs. It's always the goal to recover all of our costs and provide a rate set on a reasonable revenue deficiency. So the stipulated result is, as Ms. Lee stated many times in her testimony as well, is the result of several negotiations among all of these issues. And just as it does in any rate-making proceeding, SPS will have to manage its cost to achieve that agreed upon revenue increase and recover that deficiency.
And to that point that you just made at the end, what are the real life practical implications of having a revenue deficiency decreased practically by half from 178 million to 90 million? In real life terms, what will get not paid for?
I think if we look back to my testimony in support of the stipulation, I provided a table that demonstrates all of the drivers of the 90 million as compared to what's in current rates. A lot of the decrease, and you can see this too in the table AMJ Stip R1, much of the decrease is due to negotiations related to our return on equity, and also many of the underlying cost of service parameters like our cost of capital or capital structure, labor escalators, jurisdictional allocators. But essentially, that table that I provided in my testimony in support of the stipulation shows that the increases in both our load growth offset by the revenue increase that will result from the rates would allow us to accomplish that earning that kind of revenue deficiency while also maintaining a safe and reliable system for our customers. So I think throughout the negotiations of the stipulation, SPS has determined, as Ms. Lee's put in her testimony, the various puts and takes that would allow us to achieve this revenue deficiency while also maintaining both a safe and reliable system for our customers.
Are there any employee salary increases that are not happening due to the decrease from 175 million to 90 million?
I do not know. These costs, again, are representative of a future test year. So a lot of those decisions have not occurred, and I would not be knowledgeable about those.
Are there any capital expenditures not being made due to the decrease from approximately 175 million to 90 million?
I don't believe so, no.
All right, I'd like to actually move towards the table itself. And I do not have a question about every single line item. But I would like to go to the line item that says new depreciation rates, 12,834,733. Do you see that?
I do.
Okay, thank you. The stipulation, as we just heard Ms. Keitzman testify, stated that the STIP's depreciation rates would have a net impact on the revenue deficiency of $0, but then your table is showing a $12.8 million reduction for new depreciation rates. Could you explain the discrepancy between those two items?
Yes, so the $12.8 million represents the increase in depreciation to the New Mexico retail jurisdiction based on the proposed new depreciation rates. Since it was stipulated that we would not increase depreciation, therefore our initial filing, so this, I guess I should step back a minute. So this table is meant to walk forward from our initial filing of the 175 million down to the stipulated revenue increase of 90 million. So that what that 12.8 represents, that was the increase in our initial filing. So our initial ask to increase depreciation rates resulted in an increase of $12.8 million to the New Mexico retail jurisdiction. So as we agreed to not increase depreciation and instead keeps the revenue requirement impact to zero, this is demonstrating that we are removing the impact of increasing the depreciation rates from our initial revenue deficiency of the 175 million.
Thank you. That I believe that explains it. Okay, I want to move down to removing cash working capital of 3.4 million approximately. I believe that in your testimony, Ms. Johnson, in support of the stipulation, you stated that, but it is not expressly stated in the stipulation. Is that correct?
I believe the stipulation states that the cash working capital will be set at zero. In our initial application, SPS proposed what we refer to as the 1/8 method. So cash working capital would be set at 1/8 of O&M expense. But in the stipulation, we agreed to set cash working capital at zero. So that 1/8 method, if you will, was worth that $3.5 million figure you see there in the table.
Okay, thank you. Want to go down to adjust community solar garden, 235,000 approximately. This is a small amount, I agree, but are you aware that in Miss Lee's rebuttal, she's on page 63, she states that O&M costs are supported by Allison Johnson's work paper entitled SPS K&M Community Solar Adjustment. But in that work paper, it's just a number without support. Do you agree with that?
I agree that what's in the work paper was just the amount identified here without further support, and thus I'm trying to remember what that amount represents. I believe it represented some type of legal costs associated with the community solar garden program that was in staff's direct testimony, that we agreed, if not well supported, that SPS would be willing to remove that from the cost of service, and which you see demonstrated here. We removed the 235,000 from the cost of service.
Okay, I want to move down to non-defined reductions of approximately 1.9 million and total reductions of approximately 85 million. Is that correct?
That's correct.
And so if you add those two together, the total reductions are approximately 85 million, but the revenue deficiency is 90 million. Is that correct?
That's correct. The 85 million in total reductions represents the difference between the stipulated revenue deficiency of 90 million and our original ask, our original revenue deficiency of 175 million.
Right. So isn't that approximately $5 million of adjustments, or as you call them, there's a difference between 90 million and 85 million, that's 5 million, is that correct?
That's correct, but the 85 million represents the difference between 175 and the 90.
Okay, so
the 85 million is not correlated to the revenue deficiency of 90 million. It's just showing you the total reduction that had to be achieved to work from our initial request of 175 to meet the stipulated request of 90.
okay, so it is your conclusion that the 1.9 million are the only unspecified reductions?
That's correct. That's the difference between all of the reductions and some increases, I suppose, to arrive at the 90 million that couldn't be specifically isolated to a particular issue.
Okay. I'd like to move on to your testimony. I believe this is in your testimony in support of the stipulation. Oh gosh, I wish I had the page. And so maybe I'll come back to this later because I have to look for the page number. And I want to keep going. I would like to ask you about the jurisdictional allocation. You're responsible as SPS's revenue requirement witness for calculating the jurisdictional allocation percentages that apply to the various components in the cost of service. Is that correct?
That's correct.
And to develop New Mexico's retail revenue requirement, you utilized a forecasted 12 CP demand allocator for the future test year ending November 2027. Is that correct?
To come up with the total revenue requirement, we used a 12 CP. Was that the question?
Yes.
That's not accurate. So the total cost of service, every account utilizes varying jurisdictional allocators. As I describe in my testimony, some accounts use defined allocators such as the 12 CP. Other accounts use systematically derived allocators. So to come up with the total revenue requirement, it's the sum total of the cost of all the accounts within the cost of service as they are jurisdictionally allocated, but each account has a specific jurisdictional allocator assigned to it, and that can vary depending on the underlying FERC account.
Okay, but for some of those line items, you did use a forecasted 12 CP demand allocator for the future test year ending in November 2027.
Correct.
Okay.
For those accounts where it's appropriate to use a demand allocator to jurisdictionalize values, we did.
So isn't it true that SPS projects production demand in New Mexico that will increase by 31% in the future test year?
I think that question would be better answered by SPS's witness, Mr. Taylor Hurt, regarding specific forecasted jurisdictional allocators, particularly 12 CP. I don't produce that forecast.
Do you agree that by using this future test year allocator, SPS has the end result is that SPS has assigned a significantly larger share of SPS's total system costs to New Mexico than Texas?
I would agree that generally speaking, as the jurisdictional allocators increase, that would cause using our standard cost of service study methodology and cost causation, that would allow more costs to be allocated to the jurisdictional with a greater percentage.
And you agree that New Mexico has a production demand increase that's higher than the Texas production demand.
Objection calls for speculation. Ms. Johnson's already explained that Mr. Hurt is the one who is making this calculation.
Samer, do you have a response?
Yes, I believe it's in her testimony as well.
Okay, I'm going to overrule the objection. I think this is something that the witness can answer to the best of her knowledge.
Yeah, if it would be helpful if you could point me in my testimony where I compare the New Mexico future test year 12 CP allocator to the Texas allocator. I just don't recall those, specific percentages off the top of my head. But again, to answer your question, I would say generally speaking, if a percentage allocation were to increase, then the cost assigned to that jurisdiction would in turn increase.
You're aware that Texas prohibits the use of a fully forecasted future test year. Is that correct?
I am aware that we use a historical test year in Texas.
Right. And it's adjusted for known and measurable changes. Is that correct?
I believe so. However, I have not produced a cost of service for a Texas rate case before.
Okay. If SPS is using an inflated forecasted 12 CP allocator to assign costs to New Mexico, but in Texas must use a historical 12 CP allocator that assigns a lower share of cost to Texas, doesn't that over allocate to New Mexico the company's costs?
Can you repeat the question for me, please?
Okay. If SPS uses an inflated forecasted 12 CP allocator to assign cost to New Mexico, but in Texas must use a historical 12 CP allocator that assigns a lower share of costs to Texas, doesn't that over allocate to New Mexico SPS's company's cost?
I do think any questions regarding specific jurisdictional allocators would be better answered by Mr. Hurt. But generally speaking, they're two different methodologies. I would disagree with the term inflated allocator. All of our forecasted allocators are based on our future test year and the load obligations we expect to serve during that time period. But again, I'm not the expert on the forecasted allocators versus what they would be in a historical test year basis.
Thank you. Have you read Dr. Larry Blank's direct testimony?
I have. I've read some of it.
Okay. And did he recommend using a historical base period data solely for calculating the jurisdictional split?
Again, I think that question would be better answered by SPS witness Mr. Hurt or Mr. Trowbridge, but I do recall that as the recommendation, his recommendation.
And do you think that's a reasonable process to be used to cure any kind of over allocation? and prevent SPS from double recovering its revenue requirement?
I do not, because essentially you're creating a mismatch between the time periods requested in the case and how you are allocating costs. So if we are producing a cost of service based on a future test year, and therefore our revenue deficiency is calculated by using estimated future test year costs to allocate those costs based on historical load factors would be a mismatch. And generally outside of normal rate making procedures.
Are you talking about the matching principle?
Yes, because essentially you'd be allocating future costs that SPS anticipates it will occur based on a historical allocation methodology.
Do you agree there could be exceptions imposed by the commission to the matching principle if necessary to create fair, just, and reasonable rates?
Objection calls for a legal opinion.
Ms. Amer?
I will rephrase the question. Hopefully this will be better. Is the commission allowed to vary from the matching principle if it decides to do so?
Objection calls for a legal opinion.
No, I'm asking about the commission's authority.
Right, under the law.
Well, to me, this is something that if she's going to testify about the matching principle, she should know whether or not it's absolute or whether it is not absolute.
Okay, I'll just say, Mr. Coe, please wait to be recognized by the hearing examiner before responding. And likewise, all parties. I think that's not just appropriate, but also good for our administration here of this proceeding. So, Ms. Amer, you do not feel that this is a question that calls for a legal conclusion. For what reason?
Well, I think that technical experts know whether or not the rules that they need to apply are absolute or have exceptions to them. I think that's something that they routinely know. Oh no, this rule, no exceptions. This one, these are the exceptions.
You know, Ms. Amer, also, I'll just say for all parties here, I think sometimes a lot of objections can be avoided by laying foundation. So there may be a way for you to lay a foundation here to avoid this kind of objection. Do you want to try and reframe your line of questioning?
No, I'm just going to move on, if that's okay.
That's totally fine, Ms. Amer. It's your witness and your time.
All right, I'd like to turn your attention to page 11, exhibit 48.
Ms. Amer, sorry to interrupt. Ms. Amer, you have 1 minute left.
Okay, your rebuttal. Isn't it true that you agree that the stipulation reflects an overall base rate increase of 12.5%, while staff recommends an overall base revenue increase of approximately 6.7%?
That's correct.
Okay, and actually, I'd like to borrow like 5 minutes from our leftover time if you would let us, Mr. Hearing Examiner.
Sure, that's fine. But also coincidentally, Ms. Amer, we're up against basically a let's see, when did we got back at 2:20. So that was about an hour, 2:25. So it was an hour and 20 minutes ago. I think it's good for us to take a break. And I will set the timer here for 5 minutes once we return.
Okay.
So why don't we all take our afternoon break, 10 minutes, be back here, be back from recess at 3:55 p.m. sharp. And we will continue with staff's cross-examination of Ms. Johnson. Thank you, everybody.
I'm ready when you are, Judge.
Thank you, Mr. Lee. Good to see everybody. I think we're just about ready to go back on the record here in a few moments. Ms. Amer, are you with us? Are you ready? Ms. Amer, are you there?
Thank you. Okay, I'll pick up where I left off, which is page 11
Lost my audio
of
for some reason. I'm trying to.
Ms. Johnson's rebuttal testimony, Exhibit 48 of SPS's. And I just said the stipulation reflects an overall base revenue increase of approximately 12.5%, while staff recommended an overall base revenue increase of approximately 6.7%. So, you agree that you stated that, correct?
I did, correct.
And do you also agree that you concluded as a result that all customer classes except for secondary general service experience larger absolute percentage rate increases under the stipulation than under staff's recommendation because the total amount of revenue being recovered is substantially higher?
I don't agree. I don't believe that's stated in my testimony.
In page 11 of Exhibit 48.
48. I don't see that on page 11.
Because, okay. I'm opening it up. 9, 10, 11. Okay. I took that from, okay, now I have to find what page.
Might be either the customer class cost of service is supported by Mr. Hurt and Mr. Trowbridge.
Let me just see if I can find the page. But you do agree that the stipulation reflects an overall base revenue increase of approximately 12%, and staff recommended an overall base revenue increase of approximately 6.7%.
Yes, I do agree. The stipulation is a higher retail customer rate increase than what was proposed by staff.
Thank you. I have no further questions.
Thank you, Ms. Amer. You have a minute and a half left, which I'll keep on your ledger for you. Thank you. Ms. Hardy, do you have any redirect for your witness, Ms. Johnson?
Your Honor.
I'm sorry, Mr. Rowe. Sorry, Mr. Mr.
We're,
Coe.
we're good, Your Honor. Yes, sir. A few. Ms. Johnson, do you still have in front of you SPS Exhibit 48? It's your rebuttal testimony in support of the stipulation.
Yes, I do.
And will you turn to page 5, please?
I'm there.
And you had several questions about this table AMJ Stip R1. And I was hoping that you would back up and explain to the hearing examiners, what's the purpose of this table?
The purpose of the table is to demonstrate how we arrived at the $90 million stipulated increase based on the terms that were stated within the stipulation and other revisions to the cost of service that happened throughout the procedure in this docket, beginning from our original deficiency request of $175 million. So it's meant to demonstrate a walk forward of all testimony and results of that testimony and negotiations that occurred to arrive at the stipulated revenue increase of $90 million.
And was this table presented in response to staff testimony?
It was.
And can you explain what testimony you were responding to?
We were responding to the testimony in opposition of the stipulation by staff witness Jonah B. Malden.
No further questions, Your Honor.
Thank you, Mr. Coe. Ms. Amer, do you have any redirect on these few questions? Or sorry, recross?
No, Your Honor, no further questions.
Thank you, Ms. Amer. Hearing examiner Gecko, do you have any questions for Ms. Johnson?
I do. And I'll preface it with, I've tried to stay organized, but with some of the questions coming from elsewhere, it may take me a minute every once in a while to understand which testimony I'm referring to, because some of the questions were referred over from questions to Ms. Lees. So good afternoon, Ms. Johnson.
Good afternoon, hearing examiner Getco.
I have, just because of the questions that have been asked so far, I have one, maybe two questions of clarification about this table AMJ Stip R1. And you testified that at the time we reached the stipulated revenue increase, this table could have been provided and calculated, but only at that time. And then, you were asked, were any of these figures calculated after staff filed its testimony in opposition? And you said, no, these were all calculated at the time the stipulation was reached. What remained unknown for me was whether these calculations were shared with the signatories to the stipulation before they signed the stipulation. Were they shared with other signatories before they signed the stipulation?
So the table itself wasn't produced in order to be shared. However, as I explained, some of the adjustments were the result of negotiated terms of the stipulations. Others were, as you see kind of noted in the table, results of previous revisions to the cost of service. The revisions filed on March 20th of 2026, or the notice of correction filed on March 25th of 2026. So to answer your question, this table wasn't specifically provided to the signatories throughout the process of the stipulation, but many of these adjustments they were aware of beforehand or throughout the proceeding. Some of them were proposals in the original application. They would have been available and supported by a live cost of service model that we provided, along with numerous work papers that were provided to support all of these adjustments.
Okay, thank you. And then, and this is because of testimony that's out there. When these models are provided, there's testimony that sometimes the order of operations of those models can result in different numbers. And So my question, and I drew up an analogy, and it's, you've testified, and I'll paraphrase to, because of those agreements that had been reached or certain provisions that allowed you to arrive at these numbers that are in the table. And I think of a situation where I can have a single set of inputs. I can have two formulas. I can put those inputs into that formula, into both formulas. And that each formula can present different buckets of results. And both of those formulas could give me the same totality of all the buckets added up. So in this case, 90 million. But from the same inputs, I could get to different buckets that add up to the totality of the buckets that's the same. So with that analogy in mind, with the inputs that were understood and different agreements that you referred to, are there different ways to get to the 90 million that would have put different numbers into all these lines that are in this table? Or is it just a fact, given those inputs, these buckets would have always been exactly these? We would have had 27,982,137 in the second line, 17, etc. Can you answer that question, please?
Sure, I'll do my best to explain the models as technical as the underlying calculations are. But I think your question centers on the premise, would the drivers to get to the 90 million, the core issues, still remain the same? And yes, they would. The caveat where I kind of described that order of operations is important. All other cost of service parameters held equal, could you get to these exact dollar amounts? You could and you couldn't. If you followed the same order that we did in producing this table, then you could. But I think to answer your question, the buckets and the materiality of these adjustments would remain generally the same. But could you, in your theoretical example, could you put in all of these, adjustments and get to the exact dollar, the 27,982,137? Maybe not. And that was why I had to explain, and that the reason that maybe you couldn't get to that exact amount would be everything would have to remain equal. Your underlying cost of service parameters, such as the return on equity, the capital structure, allocators, all of those underlying adjustments, because there were so many, are very dynamic in nature. And so it would depend within our cost of service model what order you use to put those in to inform the calculation. So generally speaking, they could vary, by probably immaterial dollar amounts, but the core drivers kind of listed in order of materiality there in the table would remain the same. For example, ROE would probably still be your largest driver to get from 175 to 90 million. But you may not calculate the exact same dollar amount unless you reproduce the calculation in the exact same order that we did.
Okay. And I think this is a simple question. Signatories didn't know the exact order that you applied the drivers in, right? Before they signed the stipulation.
Right.
Okay.
I mean, they were provided the live cost of service model, as I stated earlier, and the work papers. So they were able to input the adjustments based on the underlying agreed upon terms, but they would have had to do it, for example, they'd have to have a consultant deploy the exact same order of operations, holding all other things equal, that the analysts on my team did to produce this.
Okay, thank you. And then I'm trying to go back just a little bit here. I just think it felt important, so the clarity seems important. I'm almost there. So on redirect, you were asked, what's the purpose of this table? And your answer was that the purpose of this table, and this is your answer in part, the purpose of the table is meant to demonstrate how we arrived at the $90 million stipulated increase based on the terms that were stated within the stipulation. Who is we? Is that SPS or is that all the signatories?
All the signatories and SPS.
Okay. Okay. I get it generally. It's just a little bit, it's a reflection of my mind. If the other parties didn't know the order that you went to and the numbers would be a little bit different, then how would the other parties have arrived at these exact numbers? And so how does we apply to all of the signatories?
In terms of how they would arrive at these exact numbers, you mean, or can you clarify?
Well, if we don't have certainty that they arrived at these exact same numbers because they didn't know your order of operations, how can we say that a group that didn't have this table and didn't have the order of operations is included in the term we, for we arrived at these numbers?
Right. Well, many of the signatories, as they produce their own direct testimony, utilized our live model and work papers to support their own calculations and position as they arrived, to negotiation for the stipulation. So many of the signatories provided, detailed models of their own within their testimony, utilizing our work papers to support their individual proposals. So I suppose when I say we, it's more of a generalized statement that these calculations are results that we can all, of terms, underlying terms that produce the calculation, so the signatories can support, or able to support their proposals within negotiations, as SPS was able to support ours, utilizing, the same underlying cost of service model and work papers.
Okay, that's clear. That's helpful. Thank you for that. Thank you for the clarifications. Okay. I asked a few questions about both rate case expenses as well as production tax credits to Ms. Lees, and she referred me to ask you, and I know there's other individuals that work on taxes in your application as well, but let's see where we get.
Sure, I'll do my best.
So one of the lines of questions was with respect to the stipulated base rate increase, including recovery of $4,342,331 in requested rate case expenses and previous regulatory proceeding expenses to be recovered over 2 years. And so I asked the question, if those are amortized over 2 years, so it's about $2,150,000 is estimated as an amortization expense, and we don't, or SPS for some quirk doesn't file a rate case for a period of time, that means that the rates that the commission orders to go into effect in this case operate for 4 calendar years, for example. What I'm not educated on is whether that would mean that the $2,150,000 approximately amortization expense would be in rates for all 4 years, or whether, this is a blind spot in my knowledge. There's a mechanism where that 2,150,000 approximately is recovered only for 2 years in rates, and nothing beyond the total of the stipulated total of 4,300,000, et cetera, is collected. Can you explain to me whether there would be a mechanism so that we're capped at the stipulated amount of rate case expenses, or whether the collection would go on the amortization expense in future years?
The collection would continue because rates are established based on that cost that is built within the cost of service. So if we have $4 million built within to develop our rate, we are going to continue to collect at that level until we file another rate case. We won't continue to defer additional rate case expenses. So if we are to incur rate case expenses in excess of that 4 million, that would simply hit expense.
I'm sorry, can you explain that last piece again? I was still on your first explanation, and when you went to the expense.
Yeah, so rates will be set at that $4 million rate, so we'll continue to collect revenue based on that underlying cost that was used to establish our rates. So that 4 million will continue in absent a new rate case where we establish new rates. I think what's important to note is that we won't, and related to your question around the amortization specifically, is that we cannot, under the stipulation, defer additional expense. So we will not accrue and amortize more rate case expenses. If we were to incur, if our actual costs incur are greater than what we estimated, then that would simply hit expense, and SPS would be, in terms of rate case expenses, then SPS would be under recovering because the rates are set at that $4 million value.
Like, for example, if it actually was a $5 million in actual costs, you wouldn't be able to change your annual amortization expense in the future test year.
Correct. We wouldn't be able to change it until our next rate case.
But if it was a $5 million actual and you had a $2 million amortization expense, and those rates were in effect for 3 years, you'd collect $6 million, even though your actual rate case expenses were $5 million, correct?
No, you'd collect the 5 million. That was the basis for setting the rates.
No, sorry. My example was, okay,
Sorry.
let's assume that,
Maybe I didn't follow.
let's assume that the future test year, judges the rates to be $4,342,331, and they're amortized over 2 years, so it's $2,150,000 approximately. And then when you all actually do your books and get your bills, and this rate case is over, and you look at the books and, oh man, we spent $5 million, and we stipulated to 4,300,000. But then those rates that are established on the future test year stay in effect for 3 calendar years of rate collection. You would collect $6 million, $6,450,000 approximately in rate case expenses over the course of 3 years that those rates are in effect. Is that correct?
No, we would collect only what our rates are predicated on. So we're only going to collect the $4 million in rate case expenses because that's the revenue that is established in the cost of service for that particular amount.
Okay. So how does that work then? That's where I don't understand, because I always think, okay, this sets rates. Rates go into effect. Those rates stay into effect until we get to another rate case. The base rates are set off. The amortization expense for these rate case expenses is put into what the future test year revenue requirement is. So now we get to the end of 2 years and SPS is collected. Let's imagine a situation where your predicted load matches up absolutely perfect with what actuality is.
Right.
And so at the end of 2 years, you've collected $4 million, 342,331. How do you, I'm just totally ignorant to it. How do you stop collecting rate case expenses that are in the rates as calculated according to the future test year once you reach that $4,300,000 mark? That's what I don't understand.
Sorry, I'm just trying to think like the best way to describe it. So you don't stop collecting because you're still getting revenue based on that underlying revenue requirement and or rates are established, but because it's a future test year and your actual costs are not known, I mean, there's probability that you could under collect on some issues and over collect on others.
So there's a possibility you could over collect on rate case expenses. Correct? A possibility.
Sorry, it's difficult to explain because we don't, particularly isolate, the revenue that we come into any particular issue. It's set on the, the total revenue requirement. But I would say, generally speaking, there's a possibility that yes, you could over collect on any one expense.
Okay, thank you. That's helpful there. Okay, thank you. Yeah. Yeah, sometimes. Okay, thank you. Let me go through here and try to stay organized. Ms. Lees testified that there's not a return on the rate case expenses. Is that correct? If they're in base rates?
That's correct. There's not a return on the regulatory asset for which we defer rate case expenses into. And in fact, there are other regulatory assets where we also do not collect a return.
Okay, thank you. And I don't know if you've been watching, but when I'm just staring like this, it's me scrolling through the questions.
That's okay. I got a lot of testimony, so take your time.
So the application and the testimony, just because we're on this topic and it's similar, establishes that Cunningham Unit 2 will close in 2027 and establishes that there's approximately an $11 million depreciation expense on that. So similarly, while rates established through this future test year are in effect, that depreciation expense that is for Cunningham Unit 2 during the future test year will continue to function as an element in the rates that continue to be collected beyond the closure of Cunningham Unit 2, correct?
I believe that's correct.
Okay. And is that what somebody might refer to as regulatory lag that's in that case in favor of SPS, as opposed to a case where SPS makes investments and incurs costs that aren't in rates, and therefore there's a regulatory lag that people generally understand as harming the utilities cash flow. Would you agree with that?
Yeah, that's correct.
Okay. And are you aware of total amounts of costs in the future test year that are used to generate rates in the future test year, costs or depreciation, amortization, that are for assets or resources that will not be in service after the future test year or within the next year, I would say, after the future test year?
I'm not specifically aware of those. I'd probably hate to refer to someone that's already testified, but anything related to depreciation would probably be best answered by Ms. Keatsman, or anything related to the specific operations of our facilities and when they plan to retire is likely supported by our energy supply witness, Mr. Heffington.
Okay, thank you. Oh, going back to the rate case expenses, sorry. Like I said, I had to move questions around.
Okay.
So we got to a point where, there's a possibility that, and I understand, the total revenue requirement and what went into creating that revenue requirement. And, SPS tries to run its business once rates have been established to accomplish that revenue requirement, et cetera. And so that exact tracking maybe breaks down between what that amortization expense is and the actual revenues received in the third year after rates are set. But setting that aside, because we set rates based on all these elements that we see in your table, AMJ, STIP R1, would it make, and here's how I asked it to Ms. Lees, my understanding of reading the stipulation is that if you haven't recovered the $4,300,000 approximately in rates prior to the setting of new rates from your next rate case, you have the ability to collect in the next set of rates the amount of rate case expenses stipulated to here that you weren't able to collect in the rates that are set in this case. Is that correct?
That's correct.
And so would it make sense that since there's a possibility, which can also be spoken of as risk, that ratepayers would pay more than the stipulated rate case expenses in this case, would it make sense to amortize over 3 years so that it's guaranteed? Well, there's a greater amount of assurance that we don't live that possibility of over collecting the rate case expenses from ratepayers?
I think generally speaking, it's more of a policy and rate case strategy decision, and that the amortization periods are arbitrary, but they're meant to align with, periods that we anticipate incurring those costs, and to maximize the time between rate cases. So if we believe that it's likely we'll file a rate case within the next 2 years, then establishing the rate case expenses at that level would appear, would be reasonable for SPS and prudent representation of the cost for customers, if we believe that timing is in the best interest of all parties.
Okay, thank you. Okay, now I'm going to turn to some questions about production tax credits to try to fill out a couple things I don't understand.
Sure.
That I think are relevant to the recommendations that need to issue in this case. Okay, so production tax credits aren't always, SPS can't always use them to offset tax in the year in which they're earned. And so there's a couple options. They sit there as a regulatory asset because they've already been provided to ratepayers as a reduction in revenue requirement, or they can be turned into cash through the transfer market. And Miss Lee's made me aware, and I'm reminding myself right now that certain things about that market might be confidential. And so let's just all keep that in mind, that if I ask a question that requires that kind of answer, I fully expect, of course, that you tell me that that's a confidentiality issue. So in a prior case, I found in a final order in 23-00252-UT, a statement that SPS disagrees that it would not have incentive to sell the tax credits and instead allow them to accrue carrying costs in the deferred tax asset. Can you explain to me, like, why does is there any incentive for SPS, given that they earn a carrying cost on that deferred tax asset, to consider that value and have that affect how quickly SPS chooses to turn that into cash in the transfer market?
No, I don't believe so. I mean, I think your question is generally asking, would SPS be incentivized, to allow a DTA balance to accumulate? And the answer to that is no. I mean, SPS earns a return on that balance because we are financing the benefit that's already been provided to customers. So it's in our best interest to utilize the tax credits to offset a tax liability or to monetize them by transferring them.
And if it was a strictly monetary decision, it'd be by cashing it out and investing it or paying off debt. Could SPS earn on the amount that they receive in the cash out a greater amount than what they earn through the long-term cost of debt? Would that be a strictly mathematical calculation assessment of whether SPS should cash that out or not, if we eliminate other factors?
Yeah, potentially. I mean, I'm certainly not an expert on the transferability of market like Ms. Lee's. So Ms. Naomi Koch may be able to shed some more light on what that market looks like today, but it's an economic decision. Yeah, whether it's beneficial or not, or more beneficial.
Okay, and so being that it's an economic decision and a final order tells me that SPS has argued in other cases or asserted and has testified, that's the most innocuous word I want to give, that that SPS wouldn't be incentivized to keep that in a deferred tax asset. Do you have knowledge of that because a calculation has been done that you know it's better to use that money elsewhere? Or I mean, for me right now, it's just a statement in another final order, and there's a lot of production PTCs that exist in this case, a much larger amount than I understood before I started to look at the case. Do you do those calculations?
I don't. So when it comes to like analyzing transferability or potential contracts, I'm not involved in those. That would be our tax services team, is Ms. Naomi Koch.
Okay, thank you. So then, do you have knowledge as to, so one piece in this case is that there's, and correct me if I'm wrong, my understanding is that SPS started to receive production tax credits for Hale and Sagamore when they went into service in 2019 and 2020. And that absolutely up through 2022, SPS wasn't able to turn those into cash in the transfer market. And do you know whether that prior to 2022, SPS was able to offset tax payment requirements with those PTCs that they earned from Hale and Sagamore?
I don't have that specific knowledge.
Do you know whether there at this point are production tax credit amounts on SPS's books from Hale and Sagamore that originated prior to 2024?
From unused balances? I believe, again, I would think that's a question best answered by Miss Naomi Koch. I do believe that we provided some response to staff discovery specific to Hale and Sagamore PTCs and current balances, where the DTA was, what credits came from which vintages that were unused in prior. I think we've provided some of that information in discovery.
Okay, and is it traceable? That's been I wondered, does it go into a big bucket, similar to like a revenue requirement? Or the total amount of PTCs gets lost like an electron in the ocean of electricity? Or are you able to track back to when that PTC was came onto your books and that it's still there?
Again, I would defer the question to Miss Naomi Koch, our tax services expert. Generally speaking, I think all of our PTCs generated are used to offset tax liabilities of our total company. But I do think, I do think in some respects to your questions, PTCs go into one bucket of all PTCs generated by all the operating companies in Xcel Energy and all assets owned by Xcel Energy to offset company tax liabilities. But I do think there is transparency into the individual transfers that occur and where they come from, so to speak, and where in the pool they might have been generated or what vintage.
Because there's some requirements for the ability to use those production tax credits based on future use of resources after those PTCs are earned, correct?
Correct. And I do believe there's expiration dates of those also, so they have to be tracked to some degree.
Are you familiar with the expiration date of when you can retire, when you can use a production tax credit? What's the limitation?
Sorry, I don't recall. I don't recall off the top of my head what that is.
Would it be close to 22 years?
I don't know.
Okay. So given that it requires an economic calculation, and given that we don't know how long those PTCs can sit in a regulatory asset, wouldn't it be reasonable to put a timeline limitation on how long those PTCs can sit in a regulatory asset without either being used to offset taxes or turned into cash in the transfer market, or a filing is made that shows that neither of those two were possible and provides a demonstration of why not? Because for every year they sit in a regulatory asset, and hopefully they don't have to sit long, that's additional money that gets charged to ratepayers. So given that context of my lengthy question, do you think it would be reasonable to put a limitation on the time that can go by before that PTC is utilized in one of those three manners?
I would say the expiration date somewhat defines how long the PTCs can sit in that deferred tax asset, or otherwise they're not eligible for use. So that's one incentive for SPS to utilize or monetize those prior to that date. I also feel like that supports kind of our reasoning for putting the DTA in our fuel mechanism to more, because it's more timely than base rates, and to align the benefits received passed on to customers and the costs that we incur to maintain that DTA, both within the same mechanism and a mechanism that is more timely than base rates.
I did a little calculation of applying a long-term cost of debt at 5.29% to, I just found an example of wind production tax credits in a table. It was in AMJ BR1H, which I think was filed with your direct testimony, and it doesn't matter because 5.29% can be applied to any number. But in this case, it was $162,536,560. And applying a long-term cost of debt to that amounted to $8,598,184 per year in carrying costs that are charged to ratepayers. And my calculation is that in 10 years, that would amount to $85 million. Actually, 86 if we round up a tiny bit. Do you think that's a significant, we don't know how long these are held. I'm gonna have to talk to Ms. Koch, but do you think that if, let's just say it was held for 5 years and we take the 85 million and reduce it to 42.5, and these are benefits that go through to ratepayers, do you think $42.5 million would be a number that we might label as significant for a reduction in the benefit from a production tax credits?
I guess I guess significance would depend on the materiality relationship to your total revenue deficiency.
Okay, given a $90 million revenue deficiency, would $50 million over 5 years, so 50 million as opposed to 450 million, would you deem that to be significant?
50 million in comparison to the 90 million?
I took the 90 and I did it over 5 years because the 50 million was, the 45 million was my calculation of what the cost of long-term debt would be over 5 years. So I tried to make it apples to apples over time period. And so I took the $90 million that's under consideration in this case, and maybe it's not perfect, but and maybe that's math is wrong, but I could ask it more generally. Just, do you think of, given SPS's general revenue requirements and what ratepayers pay, do you think $42.5 million is a significant amount of money to have ratepayers not benefit from, if there was an option for them to benefit from it?
I think absent all of the other prudently incurred costs that will go into designing a revenue deficiency. I mean, if you're talking in the theoretical numbers that we proposed, if it was that large of a percent of the deficiency, that would be significant.
Okay.
I think if we wanted to point to, you know, a specific example of a return on PTC DTA in my table there in AMJ STIP R1, we do have the amount associated with removing the return on the solar PTC DTA. And you can see that was worth a little over $500,000 in the $90 million deficiency. I think it's more likely a return at a long-term debt rate would produce something more insignificant to a total revenue deficiency.
Okay. I'll have to go look and see what the solar PTC.
I'm sorry, sir, I cannot hear you.
I'm sorry. I'll need. If you don't know quickly, the solar PTA DCA, what does that tie to? What is that tied to a particular solar project?
Yeah, it's tied to the 3 self-build solar projects. So it's Plan X, Cunningham 1, and Cunningham 2.
Okay, thank you. Then I ask this question: Are there any PTCs that are authorized to, when they go into a regulatory asset, that SPS earns the WACC on them according to orders in prior cases or stipulations?
I don't believe so. I don't recall for Hale and Sagamore what the circumstances were, but that DTA has also been removed from base rates.
And that sounds significant to me in removing from base rates. Can you explain that to me really quick, what you're doing there?
Exactly as stated, if there's any return on a deferred tax asset, we agreed to remove the Hale and Sagamore DTA from base rates. I believe it was a result of the 2017 Hale and Sagamore CCN wind filings, that there was a specific expiration date on that DTA. So the only component that would be, you know, reflected within the cost of service would be the return. And so I do have specific testimony about removing that.
Okay. And is the amount that was removed an amount over a threshold amount, or is it the entire amount of what that DTA was?
It was the entire New Mexico retail jurisdictional balance.
Okay, thank you. All right. I want to get to the end of this. Oh, I asked this question. In case number 2400270, which was resolved through stipulation, it was a fuel clause case. There was an agreement reached to file a report, an annual report on the sale of PTCs associated with the SPS self-built solar projects. And it includes other information. And is that information that is already being tracked and could be provided for? I mean, my question is probably not even right, because I don't know if those are in service or not. But if a bench request were issued and requested that information, is that the kind of information that could be provided in a somewhat timely fashion?
Yes, I believe so. I don't want to commit to the time, as I wouldn't come directly from my team, but again, that would come from our tax services accounting group, Miss Naomi Koch.
Okay, thank you. Okay. I have this question. In the stipulation in provision 1.11, there's a provision that says that the PTCs will be allocated on an energy basis. Do you see that there?
Getting there. I don't see the allocation specified in the stipulation.
Here, let me go there myself.
Where you were?
So I have my notes elsewhere.
Or maybe that's
So if we go to, it's on page 9 of the stipulation as filed without the errata. And there's 1.11 there that says revenue allocation and rate design.
Oh, I'm with you now. Okay.
The start of the second paragraph just says PTCs will be allocated on an energy basis. Can you explain what that means to me? And the way I gave context to this question to Ms. Lees is, you know, there's energy allocators that are out there. There's rates that are set according to kilowatt hour usage. There's, you know, energy comes up all over the place in different ways. And so I'm just trying to understand what that means. PTCs will be allocated on an energy basis.
So the energy allocator in particular is established by SPS witness Mr. Hurt. So he can definitely go into the details of how we calculate the specific energy allocator for the future test year. I can provide some kind of general context in that your earlier description was correct. You know, we have various jurisdictional allocators, some energy, some on a demand basis. But I think generally, you know, PTCs are generated, right? You get a PTC per kilowatt of generation. And so using kind of normal rate making, standard rate making practices, you would with cost causation methodology, you would allocate something derived based on generation using an energy allocator.
And so
let me, here examiner Gecko, let me just interject here for a second. We're getting very close to the end of our allotted time for today. So I want to make sure we're respectful of everybody's you know, time. And I usually like to just discuss a little bit of what's going to follow the next day. So maybe if you want to ask a few questions and we can continue with your questions tomorrow, here examiner Gecko. I just didn't want to you know, interrupt you later.
how about I just ask one question and then we go to that it's really warm.
Okay, sure. Sure.
I'd appreciate some fresh air. And excuse my ignorance here, Ms. Johnson, because there may only be one for New Mexico, but do you know the exact energy allocator that's being used to put into effect PTCs will be allocated on an energy basis?
I don't know the exact percentage off the top of my head. Something I could find.
Well, it wouldn't be this shows I'm at the edge of my knowledge. It wouldn't be it'd be a set of percentages given all the different rate classes, taking in the way that you allocate functionalized energy costs to the different rate classes, correct?
That's correct. I believe Mr. Trowbridge could explain more of the rate design process and answer that question.
Okay. I'll leave it there. I just as a preface for tomorrow, I have a couple, you know, Miss Lee's, I have some questions regarding transfer costs that I'll be asking as well. Thank you.
Thank you.
Great. Well, thank you, Ms. Johnson. You are not excused yet. We'll carry your testimony over till tomorrow. And thank you, everybody, for your patience and your professionalism today and contributing your time and energy to this proceeding. It really does make a difference. Also like to just thank Mr. Lee for his steadfast attention and efforts and all his energy and concentration he put into our proceeding today as well. So just looking ahead for tomorrow, I wanted to check in with the SPS council. I'm not sure if that should be Mr. Coe or Ms. Hardy, but just to get a sense of who would be coming tomorrow so that hearing examiner Gecko and I and the parties can get a sense of how to prepare for the proceeding.
Yes, Mr. Examiner, I can address that. Our witnesses following Ms. Johnson would be Mr. Todd Wayner and Miss Ann Bulkley, and then Taylor Hurt, followed by Alex Trowbridge. Then we have,
Okay.
After that, we have the 4 witnesses who your honors had decided you would like to hear from.
Yes, and just also on availability, Ms. Hardy, are any not available tomorrow? Mr. McGregor, I think, is not available. Is that correct?
Mr. McGregor is not available tomorrow. That's correct.
Okay. Well, we'll see if we'll cross that bridge when we get to it and take it from there. So also just to check in with any parties, are there any pressing issues or matters that anyone would like to raise? Ms. Clark, go ahead.
Thank you, Your Honor. Walmart's witness, Dr. McGovern, has had an unforeseen schedule change, and we're requesting that instead of not being called before 10:30 on Wednesday, that she not be called before 2 p.m. on Wednesday, and would appreciate your consideration.
Okay, let me just take a note of that. That would be earliest on day 3. Is that correct,
Yes.
Ms. Clark? Let me go here to, we have this all mapped out, by the way, everybody. We have a very precise matrix of witnesses. And Jamie McGovern, so earliest would be 2 p.m., correct?
Yes.
Okay, excellent. I have it here. Thank you.
Thank you.
Okay, anything else? Anybody? Any concerns procedurally that we need to address as we close today?
Miss Miller has her hands up.
Yes, Miss Miller, I think your hand is
Thank you. I
tentatively
can't find
raised.
my hand either, so I'm using my normal hand. I just found out from Mr. Gorman that he is available tomorrow, but only until 3 p.m., but he's also available on Friday. So I just wanted to make sure you knew that.
Okay, so he's only available tomorrow or Friday.
He's available tomorrow and Friday, but tomorrow only
But
until.
that's it.
That's correct.
Okay. All right. Well, we might want to take him tomorrow then. You said until 3 p.m. tomorrow?
Correct. Yes.
Okay. So let me just take a note of that here. Until 3 p.m. Okay. Because we might not, we might finish before Friday. So I want to make sure that we have Mr. Gorman's, testimony and opportunity to appear.
Okay.
Obviously. Okay. All right, everybody. Well, once again, thank you for a wonderful day, important day.
Mr. Hearing Examiner, I'm
yes,
sorry.
Mr. Elliott.
I'm sorry to interrupt the
No, it's just sometimes if the hands don't come up, I don't see the person until that person speaks. So if your hand's not working or forgot how to use your little yellow hand, don't be shy and go ahead and speak. Mr. Elliott?
Thank you. Can you just repeat to us who we have scheduled for tomorrow?
For SPS?
Yes, what witnesses we can expect to be called?
I'll let Miss Hardy repeat that.
Okay.
But I believe it was Wayne. We're going to continue with Miss Johnson, Boehner, Bulkley, Hurt, I believe, and then those are the only ones I remember off the top of my head, Miss Hardy.
Trowbridge.
Then Mr. Trowbridge, yes.
Okay.
Okay, that's correct. That's what I have here. I
And
just
then-
didn't want to.
And we'll try and get Mr. Gorman in as well. Is that
I think we're gonna, yes, I think we'll have to make arrangements for that. That's correct.
okay? And do you anticipate calling any other witnesses tomorrow? I mean, are we going to get to staff, you think?
Well, I don't think we're gonna get to staff tomorrow.
Okay.
I think that is an very outside probability.
Good.
But
Just wanted to make
yeah,
sure.
sure.
I'd like to speak to that a little bit too, given that the chairman's comments this morning. I think the hearing examiners should have a discussion with respect to, there's essentially a request there to ask for positions with respect to fairness and jurisdictional issues moving forward and from the signatories to the stipulation. And so I have it on my mind to speak with my co-hearing examiner and see how that might affect things as well. Because that could interject. I don't know. I haven't looked exactly at the chart just now and who was all included in that, but I feel like I need to honor the chairman's wishes and provide an opportunity for each party to speak to that. I'll go back and look at the transcript and understand and remember if I'm understanding his directive properly, but that's how I recall it at this time.
Excellent.
And the other thing I'd like to share with everybody, because using the Zoom workplace app, it's different than when you're like on Zoom through the web. And the hand lives in it under the react with the little heart there and the middle of the bottom of your screen. It's not so obvious. And you think you're going to send a heart and then you hit the heart and it says you can just raise your hand. It's like a disappointing relationship.
Well, on that note, everybody, I would like to say I've enjoyed our relationship so far, and hearing examiner Gecko and I will be, prepared and online probably around 8:30 tomorrow, but we'll open the Zoom a little bit before 9 before we go on YouTube to see if there's anything that has come up in the interim that the parties need to discuss. So with that, have a great afternoon, everybody, and look forward to seeing you all tomorrow at a little before 9. Thanks so much.
Thank you.
Thank you.
Thank you. Thank you.